2024. Heidi, could you call the roll, please?
Alvin Keimer,
Present.
Christine Brochu,
Here.
Keith Kyle,
Here.
Ellen Flynn, Cornell,
Here.
Christopher Allman,
He is en route.
Anthony Brunetti,
Here.
James Manning.
Here.
Mr. Chairman, you have 6 members present.
Thank you, Heidi.
Welcome.
We should see Chris. His ETA is somewhere around 7:45. He's coming from Boston. Okay. All right, let's do this. Let's do the approval of the minutes for March 21st, 2024, and April 18th, 2024. What is the board's pleasure?
Move to accept and place on file. Second.
Motion's been made and properly seconded. Is there any discussion? Hearing none, all those in favor? Aye. Opposed, that motion carries 6-0. Okay, this evening, we've got a few changes. Sorrow will not be heard this evening. They've chosen to go to municipal court with the NOV. So if you're here for Sorrow, it will not be heard.
So just a
Would you like a
motion
motion,
to
Steve?
table? Yes, please.
Table it, or?
Yes, a motion to table.
Okay, Chair would entertain a motion that we table Sorrow.
So moved.
Second.
Any discussion? Hearing none, all those in favor? Aye. Opposed, that motion carries 6-0. Okay, our first item on the agenda is Rahani, but we're gonna move that, Mr. Monti, until, Chris gets in here from municipal court.
Excellent, thank you.
So that brings us to East Side LLC. And at this point, Ellen, you need to recuse. Christine, you want to come over there and be secretary, please?
Sure. Yep.
Thank you, appreciate that. Mrs. Amateur, how are you this evening?
I'm good. How are you, Mr. Chairman?
Oh, it's great.
I'm here again on the same matter, the same property that I come to see you about often.
It's amazing, isn't
Yeah.
it?
Well, we're trying.
Have you missed us?
Of course, of course. I love Narragansett.
Oh. There's a lot to love about this town.
There is, absolutely.
Well, you have the
All
floor.
Rhode Islanders love Narragansett, you know that.
Well, we know that.
No, I'm being sincere.
Yeah, I know, no. I understand that. You have the floor.
Thank you.
You're welcome.
For the record, Mr. Chairman, my name is Kelly Morris Salvatore. I have offices in Providence, and I'm here tonight representing Eastside Realty relating to 11 Walcott Street with Mr. Edward Pimentel. So you have seen an earlier version of our application that's been pending for some time, actually. I'd like to just go over a little bit of the history and what we're doing here tonight. So we originally filed a request for dimensional variances for lot area, building coverage, and lot width. And then we have this 1994 decision that we're asking you to take a look at tonight. There was a condition imposed in 1994, 30 years ago, that imposed a condition that the property be used only for a single-family house. So we're going to take that second. We'd like to talk about the variances first. As you know, the state law has changed, and as a result, we no longer need a variance for lot area. So the fact that this is on a 10,000 plus square foot lot is no longer at issue. A two-family or a duplex is allowed by right on this piece of property. In addition, we needed a building coverage requirement. In fact, that was the 1994 variance. It was for building coverage. Because of that proportionate reduction that I think you're now familiar with, we no longer need that. And we actually got a zoning determination from Mr. Wayne Pimentel that gave us that determination. So at this point, well, let me take a step back. Pre-January 1st, the lot width requirement was 150 feet. Because of the new state law, that has been reduced to 81.75 feet. So our variance that's required at this point is only 11.75 feet. That's the only variance that we're looking for tonight. Of course, there's also new standards under dimensional variance, the dimensional variance statute. So we're going to be talking about those as well. At this point, well, I want to start out with preliminarily. I received the entire packet that you have. I asked for that before we came tonight. There's some material that you have before you that is entirely irrelevant to this application. For example, you have pages and pages of what are purported complaints. There's photographs. I'd like you to disregard all of that. Has nothing to do with this application. And it's inappropriate for you to be looking at any of that. In addition, there's a listing of, it appears to be a historical timeline. We don't know who put this together, what it means. Again, not related to a lot with variance, nor is it related to the 1994 decision. So we're going to ask you to disregard this as well. At this point, I'm just going to ask Ed Pimentel to get up, give his resume. I hope you accept him as an expert, and he's going to testify in the form of a narrative, if that's okay with you, Mr. Chairman, and then I'll fill in with questions.
Okay.
Thank you.
Now, for the purposes of this public hearing, Mr. Pimentel will be recognized as an expert in land use and planning.
Thank you.
And could you please swear Mr. Pimentel?
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. For the record, it's Edward Pimentel, P as in Paul, I-M-E-N-T-E-L. I will speak slowly.
Thank you.
So, obviously, because of the new Rhode Island general laws, it really narrowed the focus of my analysis on this property. Because the lot is now treated as a classic substandard lot of record, the analogy would be, much as this board is familiar with, and I presented before this board, as if this was an unimproved parcel and we were asking permission to put a single family. And it was driving the need for variances and so forth, because you're entitled to by right usage of your property, right? A two-family is a by right use. An applicant can pursue whatever by right use they are associated with their property, and they're entitled to reasonable relief. In fact, I would argue that unlike your typical substandard lot that is so substandard, so defective, that even your actions of introducing a single family drives the need for setback relief, massing and scale, hardscape, softscape, because the lot's so small. In the subject circumstance, nothing is changing on the property. Regardless of the outcome tonight, and we hope we get a favorable outcome, tomorrow you're going to see the same thing. We don't need to add any additional hard surface. Parking is proficient. We're not increasing the footprint. We're not increasing the massing and scale of this facility. The one defect is the deficiency in lot width, and we cannot cure it. There's no way to get additional land area. If we had the additional 11.75 feet, the two-family would be defined as a two-family. So it is a classic variance case, and even though we don't even need to prove lease relief anymore, we were able to reduce from 3 variances down to a singular variance, so it worked in our favor considerably. So in addressing the requisite now new burdens, quite sincerely, this lot has been platted as such for many, many years. It wasn't the actions of this owner or any past owner. We can't cure this deficiency, so it's not a self-created hardship. The hardship results from the configuration of the parcel as it stands today, which is now legitimately recognized by Rhode Island general law as a substandard lot of record. And that doesn't preclude the right to be able to seek a by right two-family. And then I read staff report, and I know they wrote that the lack of lot width could have some kind of negative impairment on the neighborhood, but I'm looking at it, there's nothing that's going to change on this property, so if we had the additional 11.75 feet, that would be nice. We'd have more grass area, that's always a good thing. But we're not asking to take away what we have pervious-wise to create drainage and so forth. We don't have to. We're going to keep as much green as possible. And so I can't see how, if we had the 11.75, what this perceived impact on the neighborhood would be, that would also be cured. Because like I said, we're not changing the property. If we needed to provide parking, if we were deficient in parking, we were adding parking, and that additional land area would have supported that, there's an argument. If we were adding an addition, we needed a setback, that would have supported that argument, but there's nothing changing on the property. And in fact, in doing my neighborhood analysis, literally right across the street of both is multifamily development. They're on larger lots, but the presence of multifamily is there, so I can't see how this would impact the neighborhood, that a single family is not going to be called a two-family. So, having said that, I believe we meet the respective burdens. I don't believe it's going to impact the character of the neighborhood. And the new standard for mere inconvenience is that if it's not granted, it means that the relief sought is minimal toward reasonable enjoyment of the permitted use. So, reasonable enjoyment of the permitted use, minimal. It's a singular dimensional variance we cannot do. I believe we absolutely meet the mere inconvenience threshold. And the application is really that simple.
Okay.
I don't know if you have any questions.
Yeah, I only have one question, which is, I just want to make sure, in the staff report, it says 12.35.
I would
Sounds like that's
prefer,
been changed, or maybe you can clarify that.
Yeah, no, I'd be happy to, sure.
Yeah.
So
Minor point. But.
mhm. There are 3 variance numbers called out. The first one was a letter, January 4th, 2024, from Ms. Morris, referring to the variance at 12.21, and then on February 7th, it's referred to as 12.35. Mr. Pimentel refers to the variance requested in his second report on page 9 of 11 as 11.75. So
just
we
so
used the 12.35, which I think was the first number that came in.
so how, it's on page 10 of 11, so the lot area, I did the calculations at the very top. So the lot area is 10,900 square feet, and if you divide that by what the zoning requirement is for this property of 20,000, you end up with a factor of 0.545. You multiply that by the lot width, because that's what you need to meet, because the deficiency is what you're entitled to. And it comes out to 81.75, the difference being 11.75, but I leave it to Mr. Pimentel as the zoning official. It's his call, so.
I mean, it's just a point of clarification. It's a
Yes.
foot or so different. I just wanted to understand what that was about.
I think that our position is, and you know, frankly, you know that lawyers do not do math. So we've got 2 people that probably do better math than I did. The problem is there's different lot frontages, so I think Mr. Pimentel, Wayne Pimentel, took kind of an average to get to, I think he did, but I'll let him speak for himself. But whatever, I'd prefer the 12.83 just to make sure that we have it. But, you know, again, that's de minimis. We're looking for the lot width variance that will allow us to have a permitted use on the property. That's really what we're looking for.
Run away.
Mr. Pimentel, did you give any thought to the intensification, the use regarding the surrounding properties? As far as, I know Ms. Salvatore would like us to not look at the NOVs, but there's quite a history with this property.
Yeah, so that's something I can't respond to because those are enforcement issues, right? So,
Well, no, but I'm just saying
So let me, how about I answer this way? If we didn't have any NOVs with this property, let's say this is a totally different neighborhood, no complaints, nothing, and we're just simply asking for the same thing, would it come into play? The answer is it wouldn't and it shouldn't, because it comes down to, is the lot width variance appropriate? And that's really,
But I still think it's a consideration for I mean, we have to take into consideration the neighborhood.
but
We're obligated to.
But how does 11.75 relate to the appropriateness of the?
No, I'm just talking about,
Oh,
you're
was that
going,
at 12 point?
Yeah, whatever.
Whatever it is.
you're going from a single family to a duplex.
I understand, but that's an interesting argument, and she has all the case law with her.
Right.
But you have the right to pursue a by right land use, right? It's like
Oh,
saying-
absolutely, I'm not denying that.
But that's the point, right? The neighborhood is single, the 2-family, there's history. I don't know what that history is, and I want to get involved in history. I'm just looking at it from the blinders. Are we entitled to this 2-family because all we need is a lot with families, and I'm saying professionally, yes.
And I can also add to that. So the impact to the surrounding area is the use of the property as a duplex. So nothing at all is changing here. Same number of bedrooms. They're literally just gonna cut the building in half with a firewall and, maybe an emergency door. But nothing is gonna change on that property. It is not gonna affect the surrounding area. And with regard to the NOVs that you're talking about, I'm not sure what NOVs you're talking about, but I only know of two. And one is that four unrelated people, you found that more than four unrelated people were residing there. That's on appeal, but how does that relate? Just the fact that four unrelated people are living there does not constitute an impact on the surrounding area. I mean, if five related people were living there, that doesn't mean that there's an impact. And the other violation, which has not been adjudicated, is that the tenant allegedly did not provide a copy of the lease. So again, how does the failure, if that's proven true, how does that affect the surrounding area? It does not. There are no other violations on this property at all. So complaints prove nothing. I could call the police department on my neighbor every single day.
I understand that.
So I don't want to get too much into that. I don't want to go down that road. But there is absolutely no impact to the surrounding property based on the proposed use, which is a by right use.
And to reiterate, because I want to put on the record, if we had the additional 12.3, 11.7, whatever that is, if we had it, we wouldn't be here, right?
You don't have it.
No, I know, but you're tying it back to the impact on the
No,
neighborhood.
I understand.
So how does that, if you're formulating an impact in your mind, and we have a 12, that impact in mind has been cured? How? What was it resulting from that the 12 cured it? I don't see that, but that's my opinion on the record.
And then the other thing we have to consider is the 1994 zoning board decision.
So that's a separate matter. So I think that we've concluded our presentation on the variance. And at this point, I think we talk separately about the 1994 condition. You can make a finding on this variance first, and then I would suggest, obviously, Mr. Marcello is going to tell you, but I would think the second issue requires another vote. So, may I?
Absolutely.
So with regard to the 1994 decision, condition, 30 years ago, a prior owner of 11 Walcott Street requested a variance for building coverage, which is no longer needed, to add about 230 square feet more to the building than what is allowed back in 1994. According to town records, the intent was to add a bedroom for the owner. Apparently, the town boards at the time, we only have documents to look at, wanted to be sure that the additional building coverage did not evolve into a second unit. Presumably something that was permitted by right at the time. I don't have the 1994 ordinance. The zoning board's decision includes a condition that the house remain a single-family residence. And that's it. No other permitted uses. Not a duplex, not anything else in your use table. Since that time, and as of January 1st, 2024, the property no longer requires that same building coverage variance that they got in 1994. We're not seeking to add or otherwise further improve this property other than to simply separate the structure into two units. Nothing else will change. Now, we take the position, and we've talked to Mr. Marcella about this, that because the building coverage variance is no longer needed, the 1994 decision is moot. And so is the condition that the house remain a single-family property. But notwithstanding our position, the town staff has taken the position that the condition remains on a mooted variance decision. Therefore, in order to be efficient and perhaps to exhaust our remedies here at the town level, we're asking that you review the 1994 condition and reverse that condition. So there's an abundance of case law that provides that when there is a material change in circumstances between the time a decision was made back in 1994 and the current application today, the board may consider that new application. It's called administrative finality. I'm sure you've heard the term. This is unusual, again, because the underlying variance for the building coverage is no longer necessary. So in any event, our material change is that we no longer need the building coverage requirement because of state law. That's clearly a material change in circumstances. So we have relied on several cases that's outlined in my March 19th letter to you. I want to focus on a case called Perfido versus the Zoning Board of New Shoreham. That was a case that was decided on July 30th, 2009 by Judge Thompson. The Superior Court issued an opinion that had very similar facts in this matter. In Perfido, there was a 1998 zoning board decision that essentially allowed construction of a garage within the setback area. The zoning board imposed two conditions: that there be no habitation in the garage now or in the future, and that there will be no plumbing in the garage. In 2003, the same owners, the same exact owners from 1998, applied for further dimensional relief to convert that same garage into an accessory dwelling unit. The board denied that relief, relying on the 1998 condition. There had been an intervening amendment to the zoning ordinance permitting the accessory dwelling unit, which was the basis of the request. So that was their material change in circumstances. The court actually held that administrative finality didn't even apply and that they didn't need to show a material change in circumstances because the applicant did not seek the same relief in both applications. So one was to construct a garage, and the second was to convert that garage, that same garage, to an ADU. Similarly here, the 1994 decision was for an addition to add a bedroom, and the application before you tonight is different. It's to convert the entire structure to the by right duplex use. Additionally, we obviously have that change in material circumstances that we just discussed. The court also opined that the failure to appeal so there were other matters that I just want to kind of quickly go over. They also opined that failure to appeal the original decision with the condition did not constitute a self-created hardship, that there was no statute of limitations issue. I don't think that staff is arguing that. I haven't heard that, but I just wanted to mention it. The court in Perfido also said that they discussed the more than a mere inconvenience standard and went back as far as 1968 in the Westminster Court versus Providence case, where the court said that the proper inquiry is whether the applicants would be able to have a full enjoyment of a legally permitted by right use without obtaining the requested variance. And that's what Mr. Pimentel just summarized to you. We have a by right use. We're looking for a minor, de minimis lot with variance. The other thing I want to say about that condition is, and I put this in my March 19th correspondence to you, the authority of zoning boards of review is limited in scope to that expressly conferred by statute. The Rhode Island Supreme Court has stated that a zoning board of review is bound by the plain provisions of the zoning ordinance, and any attempt to amend it is clearly beyond the powers expressly delegated to the board. Any such change that can be brought about only by the body authorized to enact and amend the ordinance, which would be the Town Council of Narragansett. The Supreme Court has further stated that the zoning board may not, either directly or indirectly, act so as to, in effect, amend the provisions of a zoning ordinance, and that it is without authority to nullify the pertinent provisions of the ordinance. So in the 1994 decision, that owner didn't care that that they put that condition on. They didn't want a single family. But that was an illegal condition. The zoning board has no authority to put a condition that you cannot have a permitted use on your property. So not only do we have the material change of circumstances, but we also have an illegal condition that happened to not be appealed. So with that, and I think this is more of a legal issue than it is, for Mr. Pimentel to speak on, but that board had no authority to place that condition. We have a material change in circumstances. You cannot now place that condition on a variance. So I'm asking you to dissolve that condition. Again, I take the position that it already is dissolved, but I'd like, so that we don't have to further appeal this and challenge this, I'd like a decision from this board that that condition is moot and is no longer in effect. So those are our two asks. Our asks are a very minor lot width variance, and that you remove that condition from the 1994 decision based on a material change of circumstances and the fact that it is an illegal condition. Any questions?
I'm thinking.
Do you have that Profetto site, because it's not in your letter, I don't think,
I
Yeah,
have,
or does someone
I
have?
have it. I disagree with Ms. Morris.
I know, it's not in her March 19th, 2024 letter.
Yeah,
I have a copy of it.
yeah, it's Perfido ZVR Town of New Shoreham, CAWC 04-0159, 2009.
I'm sorry, I didn't.
Oh, I'm
get the
sorry,
citation.
WC 04
Yep,
dash 0159, RI Super, 2009.
Well, I'd be happy to respond when Mr. Marcello gives his interpretation.
So I just, nothing is, I'm here to advise you not to get into a legal, you certainly can respond, but I'm not here, I'm here to advise them, not here to
And that's what I'm
obviously
telling
argue
them.
with you tonight.
That's what I'm telling them. I'd love to respond.
And if they allow you, you can.
Okay.
Do you have anything else to add?
Not
at
right
this time?
now, but I would like a chance to respond, obviously, to any comments or legal interpretations.
So,
Steve, would you like to go ahead now?
sure,
Okay.
absolutely. So, first of all, it's my opinion that the 1994 decision is not moot. The only entity that could declare it moot, they first asked Wayne to declare it moot, then they asked me to declare it moot, and now they're asking you to declare it moot. So, it's my opinion that neither of those three entities can declare a prior condition moot. Something I do also disagree with, although zoning boards, there has been appeals from zoning boards when they put a condition of an allowed use, and courts have struck that down. However, those have been appeals from that actual decision, not conditions that weren't appealed and then later challenged. So we're back down to the, as Ms. Morris said, the doctrine of administrative finality, which many of you on the board, we went over in detail on the Monahan's case. But just to kind of go over what the standard is both, and I'll just read from, again, Cloxton, which was cited by Ms. Morris. Conditions attached to prior variances may be modified or removed by a zoning board if there's been a substantial or material change in circumstances. The burden is on the applicant to prove such a change. So first thing you would have to determine is if the applicant, through their testimony, either has proven, they have the burden to prove the material change in circumstances. So Supreme Court examined what a material change in circumstances is. Again, a material change will depend on the context of the particular administrative scheme and the relief which the applicant sought by the applicant, and should be determined with reference to the statute, regulation, and case law that govern the specific field. The change in circumstance may be internal to the application when an applicant seeks the same relief but makes an important change in the application. An example of that would be they come here for, you know, an 8-bedroom house, you deny it, and then they come back for a 4-bedroom house, and you make that change, whether it's a material change in circumstances, and that would certainly be one factor that you would have to determine. Or if there's an external change in circumstances, when an applicant for a zoning exception demonstrates that the essential nature of the land use in the immediate vicinity has changed since the previous application. Finally, there is a burden on the administrative decision maker, which is you, to articulate in the decision the specific material change in circumstances that warrant the relief sought. So the first burden is up to the applicant to prove that there's a material change in circumstances. The material change in circumstances can be, again, external, which, in my opinion, it's clearly not, well, obviously, you would have to make that decision, but you've heard testimony tonight that the building is staying the same, the lot is staying the same, the dimensions are staying the same, the use is certainly the ask that they're asking for. And then obviously the second thing would be external changes in circumstances, which is, again, the nature of the land use. Now, the Perfetto case, I believe, is a little bit different, because in that case, when Block Island put in that restriction of, I'll call it no ADU or no living space in the garage, that was not allowed. And then Block Island changed the law to allow ADUs or living space. The applicant came back, and again, the board denied it, but the court said that the material change in circumstance was the change in the law to allow the use, and therefore the board was incorrect in denying it, because now they allowed it. In this case, the reason why it was my opinion was that the use of a two-family was allowed in 1994. The applicant could have asked for a two-family in 1994. They would have needed lot width relief in 1994. They need lot width relief now. They obviously don't need lot area relief, so that is certainly one dimensional requirement, which is not again not needed under the new law. And as an aside, this matter is under our zoning statute, which was in place when the application was deemed complete, which Narragansett allowed two families in this zone at that time. So you're reviewing this under that circumstance. So again, I would just advise you to certainly ask the applicant for, again, if it's their burden to prove the material change in circumstances, to certainly ask any particular questions which you may deem necessary to make that determination, whether whether it's internal to the structure, whether it's external, allow, because again, you're going to have to, should you determine that there's an material change of circumstances, you're going to have to obviously enunciate those reasons why. So again, it's kind of a two-factor test, so I would obviously, if whatever they have presented so far, if you have any questions, this would be the time to certainly ask them, because obviously if it's appealed by a neighbor, whether it's in Narragansett, literally we get sued every month, so it will be appealed by someone, and so either way, whether you find for the applicant or whether you find that there's not a material change in circumstances, certainly it would be proper to enunciate your reasons, and also I can provide, if there's a legal issue that you wish Ms. Morris or I to brief, which we've done in the past, certainly whether it's to provide cases that you want to look over or whatever, I certainly can do that in writing, if you continue.
Thank you, Steve.
Question about that.
Absolutely.
I mean, I guess my question, and maybe this is the issue that might need to be briefed, but is it a material change of circumstances that the law applicable to the lot has changed? In other words, now the law applicable to that lot is that it's permitted by right.
It was permitted, well, it's not permitted by right. It was permitted by, in 1994, I can give you the opinion,
Yep.
that a two-family was permitted by right, subject to dimensional variances in 1994.
Okay.
It is now still permitted by right, subject to dimensional variances, although the variances are less.
Gotcha.
So it wasn't like in 1994, they didn't allow, two families, I went back and looked, two families have been allowed in Narragansett since the 80s, and they were allowed in this zone.
Ms. Sullivan?
Yes. So, I think Mr. Marcella actually reiterated what I just said, which is, in the Perfidio case, the accessory dwelling unit was not permitted when the original variance was granted for the garage. In 2003, it was permitted. So in our case, in 1994, the building coverage that was proposed was not permitted. In today, the building coverage that we are proposing, which is no different than what's there today, is permitted. We don't need a variance for
But
that.
you do need a variance on lot width.
No,
You
I
still-
don't need a variance. I'm only talking about building coverage, because what Mr. Marcello just said is that in 1998, Perfido did not need, accessory dwelling units were not allowed in
Mhm.
1998. In 2003, they were allowed. This is very similar. In 1994, we're only talking about building coverage, because we're talking about a decision from 1994 that we're asking you to take a look at. That decision was only about building coverage. It was not about lot width. So in 1994, the building coverage did not meet the requirements, just like the accessory dwelling unit didn't meet the requirements of the ordinance. Fast forward 2003 and today, the accessory dwelling unit was permitted and the building coverage is permitted. It's the same thing. The material change of circumstances, I don't know how you can argue this, a change in the law, a change in the comprehensive plan, a change in an ordinance, a change in the state law is clearly a material change of circumstances. And if anybody's gonna take a different position, I just don't even know where to go with that. Because there's cases and cases that say that when you change the law, that is clearly a material change of circumstances. That's what our presentation is to you tonight. There's nothing else needed. The building coverage variance is no longer needed. So in 1994, if that meant the building coverage, they could have never imposed a condition that it could be just a single family house. It was only imposed because they needed that variance. Now that's no longer needed. It's really very simple and straightforward.
But in 94, a duplex was permitted.
Yeah, I'll
By
take
right.
Mr. Marcello's representation on that. That's okay. But that's not, so
And you still are requesting a variance.
A
I
diff-
understand
a
it's
different
different than the variance that was asked
So
for.
think about what Perfido was doing, right? They, in 1998, they were asking for a garage. And the board, similar to the 1994 board in Narragansett, said, okay, you can have your garage, but we don't want you to live in it. We don't want any plumbing. Just like here, you can have your 230 square feet, but we don't want you to change this to a two-family. Fast forward, this is almost the exact same set of circumstances. We're asking to do what Perfido asked to do. We're asking to have the allowed use, but we don't need that building coverage. Administrative finality is about the decision that was previously issued. That decision was on building coverage. This is a totally different request.
All right, well, as far as that goes, then I'd like to see case law.
Yeah, again, that's where we differ. In other words,
Right,
in Perfido was not allowed, you know, the ADU was not allowed, and then it was allowed.
yeah,
Here-
that's distinctly different.
Here, a two-family was allowed, and since the building was already built, you wouldn't need to come back for building coverage. It's because the building isn't changing. You know, in other words, the site, you know, the square footage of the building is not changing.
Mhm.
So whatever variances were granted before, you don't need to come back again and you know, and ask for them again. So that's in my opinion, that's really the difference in the case. And again, you know, again, the lot is the same, the lot width is the same, but it's up to them to prove, it's up to the applicant to prove the material change in circumstances to your satisfaction.
One question, Steve.
Yep.
Did I hear you say that we're hearing this case under the old zoning ordinance?
Correct. Correct.
Okay.
No, when I say that, the Narragansett Town Council in this zone will no longer, is that past second reading?
Yes, Monday.
So it passed Monday, two families are no longer allowed in this zone going forward. However, this vested under, we have many changes. We're under the January 1 change and not under the May change.
Okay, so we are under the January
Correct.
1 change, not the previous.
Correct,
No,
yep,
Okay,
yep,
that,
yep.
thank you.
No, the town took the position that if an applicant, even though they had their application in prior, if the applicant wanted to move forward under the new law, that they certainly could, rather than having them withdraw the matter. and
Right.
come back.
Okay, got it.
Do you have anything else to add?
Not at this time, Mr.
Okay.
Chairman.
Then I would ask if there's anyone in the audience that would like to speak in favor of this proposal. No one's speaking in favor, huh? I'm surprised. All right. Is there anyone who would like to speak in opposition to this proposal? Yes, ma'am. You need to come forward and be sworn. Identify yourself.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
Judith Hay, spelled H-A-Y.
Thank you.
Thank you for hearing me. I'm the neighbor of 11 Walcott. This is me.
Okay.
That's it. I've been there since 2000. I knew Tony and Judy Monacchio very well. Sweet, sweet couple. They broke every law in Narragansett. They said they wanted to build that accessory bedroom above the garage because Tony was sick and needed another bedroom. They had 2 and possibly 3 bedrooms on the existing home. What they did was they rented illegally this side of the house, this side of the house, and stayed in that side of the house for all the years that we were there until Tony and Judy died, and the son took over and sold the house. At no time I am told were any permits pulled for anything. All his additions, all his changes, all his electrical, plumbing, et cetera, that was done. And so again, the dimensional fences, everything. The new owners have since changed again, and this owner wants to put as many people as he possibly can into this house. Where it affects the neighborhood, if it becomes a duplex, is if Narragansett has a rule no more than 4 students in a dwelling, this will allow him to put 8. He had 8 for the last 2 years, in spite of being cited many times. He never forced any of the students to leave. There've been 8 in there for the 2 years that he has owned property. That's why he wants the duplex, so he can put 8 in. Down the line, we neighbors who live there are hoping that we can get a similar law passed to limit the number of people in the summer as well. Because in the summer in this house, there have been 20 to 22 people at a time in this house. If you put a duplex in, they're going to get away with continuing to put those numbers in there. This is how it affects the neighborhood. Noise, trash, water use, sewer use, traffic, cars parked. They can't fit them all in their narrow driveways. They park on the grass, they park on the street. The police never can come by and tag anybody in this neighborhood. And that's just the people who are staying there. It's not their guests. You've got 8 people there during the winter, and you've got, if each one of them had 2 guests, you've got 24 people there. In the summer, they've got a couple of families going in on this, because believe me, he gets mega rent. So you got a couple of families, or maybe even 3 families splitting it. There's no hardship for him. Let me tell you, and there'd be no hardship if he kept to the numbers that he should. He'd still be making buku money. The hardship is on the neighborhood and the neighbors. And I can speak for my adjacent neighbors too. As you know, you've probably gotten many
Yes.
emails from them.
Yeah.
So, we have to put up with a lot. We love Narragansett, we're not leaving. We're going to stay there. But we have to put up with a lot of rentals behind us. But don't make it worse, giving this a duplex. There are no other duplexes in the neighborhood. There are no other 2 families. It's not a neighborhood where it's allowed. Not since I've been there has it ever been allowed. In fact, we were told we had to keep hush-hush about the renter we enjoyed, because he would get in trouble if the town ever found out about his renter. Thank you.
Thank you. Is there anyone else who would like to speak? Okay.
Can I just respond to that quickly, very quickly?
Sure.
Just
Early.
for the record, since it's gonna get appealed apparently. So again, I just want to remind you that the only violations on this property are the ones I listed. 2, 1 for 4 unrelated, and 1 for, again, at the municipal court across the hall for not providing a lease. Mr. Pimentel is the building official. He's the enforcer. There's no, this is not the place for testimony about an enforcement issue. In fact, it's a by right use, and we are trying to come into compliance or be compliant for future. There's nothing prohibiting my client or anybody else in Narragansett from renting. There's just nothing prohibiting it.
No, I understand that.
So again, for the record, I needed to put a response on. Thank you.
You're welcome. All right. What's the board thinking?
It's complicated.
I guess I would make a motion to continue this to the next hearing so that we can properly consider this, given the fact that there seems to be some legal issues that we need to consider and to write a decision.
What would you like as far as from the attorneys?
Yeah, let me ask with Kelly here. Do you want something in writing from both of us? Obviously, it would be from both of us. Or do you,
Yeah,
or do you just want to leave it open and you, for a written decision or?
Yeah, I think just leave it open for a written decision. I think you've cited all the cases in your letter.
Yeah.
I'll-
The only other thing, Mr. Chairman, is I did hear that you all have received emails on this case, which is a little bit concerning. I haven't seen any of them. I think I'd like to see all of them. So, I don't think they're in the packet that was provided to you,
Do we have? Heidi, do you have copies?
unless I
of those?
missed it. It could, I mean, I got this much, so maybe I missed it. but-
Yes.
These were sent to the planning board members. So they wouldn't have been in the packet, the zoning board packet, because they were the planning board members.
So it would be in the planning board packet.
But
Oh,
Chairman Manning just said that he received emails that I have
Well,
not seen.
I mean, yes, there's nothing earth shattering,
Well,
but I don't,
I mean, we're
No, I
talking
have
about
copies
ex
of-
parte communications, Mr. Chairman.
as far as I'm concerned, you're more than welcome to them.
Yeah, of course, I
mean,
don't,
it's
wouldn't think
basically
we.
neighbors that were not
Yeah,
in
but
favor.
Jim, did they come to you, or did they come to Heidi?
I thought they came through the,
No, they came to the members only.
Mhm.
I think they came to the members only, the zoning.
So, yeah, so you
Yeah,
guys would have to,
Jill.
so,
Right.
Enter them as advocate.
yeah, so you
I-
have to forward those to Heidi and
Yeah.
then have Ms.
Okay,
Morris.
is that today? Like,
Or did,
I think there may have been one today,
No, the public commentary that I have was submitted to the planning board,
Mhm.
so that was not included in their packets.
Right, I'm just looking for communications with the zoning board members.
just looking to see if they.
they came on the 21st.
He came what?
On the 21st.
Did you get one?
Yes.
I didn't read it, I don't know. I'll forward it to you.
Okay. Ms. Salvatore, as soon as I get them tomorrow morning, I'll forward them to you.
yeah, so forward them and then, yeah, well, we're gonna keep it open. Obviously, Ms. Morris would have the right to respond to them.
There it is.
So we'll just keep the matter open, forward anything that you received to Heidi, and then Heidi can print them out, put it in the packet, and forward it on to them.
So I'm not sure of what the plan is. I mean, are we drafting additional briefs? Are you looking for more information?
I'd like to put it down for decision for next month.
So, Ms.
Yeah,
Park,
it's
we,
possible.
unlike other boards, we keep the matter open and someone will draft a motion. A board member will draft a motion, read that motion into the record, and it would be voted in open session.
Okay, without further input from either one of us?
I mean, as long as,
It's up,
you have all the citations in your letter, and the only one that wasn't in there was the Fido one, so.
Right. I'm happy to send it to Heidi
Yeah,
for
that'd be great.
distribution. Okay, so there will be no more further briefing or advice to
if
the
they,
board?
if you don't want it, then, I mean, if you're not asking for it, then you're perfectly fine, then
I
I'm,
guess,
I'm
I
good.
heard their explanations, I don't.
Okay. All right,
Okay, thank you.
so,
So your next regular monthly meeting,
yes,
we'll see you
Chair
then.
would which is
June 20th.
June 20th. Chair would entertain a motion that we move this to date certain of June 20th. We'll leave it open, and this is for decision only. No further testimony.
So moved.
Second.
Any discussion? Hearing none, all those in favor? Aye. Opposed? That motion carries 5-0.
Thank you.
Thank you very much.
Have a great night.
Good luck.
Thanks, man.
You're going to recuse. Wayne is.
Yeah, so that's, I think.
Mr. Zagari?
It wasn't allowed.
I believe he's available.
Oh, okay.
He's just waiting outside. Shall I go grab him?
I think, Mr. Pimentel just.
It's like you've got exhibits. Yeah, be prepared. Be prepared. I have to write on this. Put it on
What
here.
changed? In many other things.
The appellant, do the appellant in town.
This would be.
Because this is a, for how many years of appeal. Oh, this is an appeal. Right.
All right, next item on the agenda. Mr. Zagari, good to see you.
Good to see you, Mr. Mayor.
Is Rehan, Plat NG, Lot 455, 35 Tupelo Trail. This is an appeal of the determination of Mr. Pimentel, our zoning official. Mr. Monti.
Good evening, Mr. Chairman and members of the board. Michael Monti on behalf of the appellants. So what you have before you tonight is, as you said, an appeal from the determination of the zoning official. And before we really get into it, I think it's appropriate to just set forth how we intend to proceed. I spoke with Solicitor Zangari, and we determined that I would present my argumentation first, and then he would be responding with his argument and testimony of the zoning official. So again, this is about the number of bedrooms that are permitted at the property at 35 Tupelo Trail. 35 Tupelo Trail is located west of Boston Neck Road and off Mettatuxet Road, and the zoning official made a determination that it is approved for occupancy of 4 bedrooms. We took this appeal because it's our interpretation of the building permit history and the use of the property that it is in fact approved for occupancy of 5 bedrooms since 1993 and has consistently, the town has consistently interpreted the building permit history consistent with that interpretation. So our argument tonight is really going to rely on 4 building permit applications and 2 certificates of occupancy, which are in your packets, but in a few moments, I'm going to hand you what's going to be marked as Appellant's Exhibit A, and I've got marked up for you the particular documents that I'd like to go through with you. Before we get quite there, though, I'd like to just take a brief moment to explain how this issue was brought before the board, because it's sort of an atypical one. How many bedrooms are allowed for occupancy doesn't come before this board every day. So my client purchased the property in 2017, and when she purchases the property, it's listed by RE/MAX as being a 6-bedroom, single-family home. So the first exhibit I'd like to enter, the Appellant's Exhibit A, if I may approach.
You may.
Just copies, and then I'll give one for the record, if you could just pass them down. Sure. And this one will be for the record?
Absolutely. Right here.
So this is Appellant's Exhibit A, and this is just the RE/MAX MLS listing, which shows that in 2017, the property was in fact listed as a 6-bedroom house. So my client, who's here tonight to answer any questions, she purchased the property in 2017 under the impression that it's a 6-bedroom house. Fast forward to 2023, spring and summer, the appellants filed for a rental registration, as they do every year, and they also list the property for sale because their intent is to sell the property. And so 2 things happen at that point. The first thing that happens is the rental registration folks at Town Hall ping the appellants to send a message to say, hey, this property is not a 6-bedroom property, it's a 3-bedroom property. Then, shortly thereafter, the building department sees the MLS listing for the property, which is publicly available, listed as a 6-bedroom home, single-family home, and also says, hey, this is not a 6-bedroom, this is a 3-bedroom. At that point, shortly thereafter, I get involved because this interpretation from the building department puts the sale of the property at risk. So my client was under contract to sell the property to someone for a certain amount, and that purchase and sale agreement was at stake because there was uncertainty from the building department. Hey, are we purchasing a 3-bedroom home? Are we purchasing a 6-bedroom home? We need to know that information. So when that happens, I get involved and I send a communication to Solicitor Marcella, which communication is included in your packets, but for ease of going through this presentation tonight, I'm going to have marked as Appellant's Exhibit B. This is for the record, Appellant's Exhibit B.
Okay.
So, fortunately, my client had access to the entire building permit history for this property because it had been maintained by a former owner. And so we looked through the building permit history and combed through it and said, where is it that this is approved as a 6-bedroom? Because that's what the appellants thought when they bought it. We looked at it and we find that in the building permit history, it doesn't really look like 6 bedrooms, but it's very clear that 5 bedrooms had been approved per a 1993 permit, and then that interpretation was affirmed in 2017 and 2018. So we send that letter to the solicitor and say, hey, this is our interpretation. We'd like confirmation that this property, 35 Capello Trail, is in fact approved as a 5-bedroom. And the reason that this is super necessary is because in 2021, the town of Narragansett passed a zoning ordinance that says if you have more than 4 bedrooms, that you need a special use permit. So it's very important that we get a determination that prior to 2021, this property existed as a 5-bedroom, as a pre-existing legal use. So that's what we presented to the solicitor in January, and the solicitor referred it to the zoning enforcement officer and the building official, Mr. Pimental, and Mr. Pimental came back to us and said, we disagree. Although we previously said it was approved as a 3-bedroom, based on the record and presumably what we presented, we now believe this to have been approved as a 4-bedroom.
So, Mike, if I could just interject. So, I was in part of that determination, and both me and Mr. Pimental made a good faith review of the file, and based upon our conversations, the change was made from 3 to 4 based upon the presentation which Mr. Monti did. So essentially, it went from 3 and 6 to 5 and 4, and that's,
Yeah, and that's correct.
what
That's
we-
an accurate summation. So, my client comes to me and says, we think it's 6. I look at it, we do an internal review, and we say, you know what, we think the record supports 5 very clearly. We present that to the town, who was previously at 3, and then presumably the town believes that the record supports 4. So we get the determination from the zoning officer that 4 is good, but 5 is out. And the town advises that this is a decision of the zoning and building official that can be appealed to this board. So, out of an abundance of caution and to preserve my client's rights, we made a timely appeal. You may also be aware that we immediately thereafter filed a lawsuit in the Superior Court seeking to restrain the board from hearing this appeal this evening and saying that the occupancy allowance at the property, 5 bedrooms, was a pre-existing legal use prior to the 2021 amendment. And so we went to the Superior Court judge, Solicitor Marcella was there, and we argued that this hearing should be restrained because there's no jurisdiction of this board to make a decision as to a pre-existing use. And the judge denied that request to restrain this hearing, and that's why we're here before you tonight. And so that's a long-winded way of getting to, okay, that's what happened, and now what's in front of me to look at for you to make the determination as to the occupancy allowance or number of bedrooms permitted at this property, which we continue in our objection, which is written in our appeal to you that this board is without jurisdiction. Notwithstanding, we're moving forward under protest. For the record, I want to make that clear. So, to get into the meat of it, you'll see that the packet I've handed to you as Appellant's Exhibit B has 4 green tabs. So going to the first tab, you'll see, and these are the town's records, and I don't believe it is disputed that these records are authentic, and I'm sure the town can confirm that, but here is a 1993 building permit application for 35 Tupelo Trail. It says 4 at the bottom, Bill Hansen, that was the owner at the time. And it says description of work, number 5. If everybody could take a moment to go to number 5. It says convert lower level bedrooms to a playroom and study and enlarge living room. Add second level to relocate the existing 3 bedroom to construct second story addition 25 by 33. So, and excuse me, this is actually 1986, I misspoke. This is the 1986 building permit application. So in 1986, I don't think there's any dispute that this was a 3-bedroom house. And our interpretation of this building permit and the certificate of occupancy that followed is that you had a single family home that was 1 level, they add a second level, and they put the 3 bedrooms from downstairs to upstairs, it remains a 3-bedroom. So that's the 1986 building permit. Going to the second tab is the 1993, yes?
Can I ask you a question? My first tab has a date of 5/27/93 on top of it.
That's second.
That should be the second tab?
Right, yeah, that's the second tab. If you look, this one, Mr. Monty's talking about, you look in the corner, it's 825-86, the permit number.
It should have been the 1, 2, 3, 4, the 5th document in Exhibit B. And I can give you a copy with the appropriate tabs if there was an error in that version.
So if you see that where it says 86. Al, do you have it?
I have it right
Let me hand you a packet that is appropriately tabbed. My apologies if you were given one in error. This one I've reviewed, it certainly has the appropriate tabs. So again, that first tab, our interpretation, we think this is very clear. It had a single family home, it was a 3-bedroom. Bill Hanson takes the 3 bedrooms, puts them from the first floor to the second floor. So it's, you know, most homes have the bedrooms upstairs and the living space on the first floor. Then, the second data point is the 1993 building permit application for, you see at the bottom, Bill and Candy Hanson. If we look at the description of work to be performed, which is 17, I'd like to just direct everyone's attention to that. It says, extend north section of house out 12.5. Add second floor to entire section. On first floor, move bedroom and add new family room. On second floor, add large bedroom, bathroom, and walk-in closet. So our interpretation of this 1993 building permit application, which did receive a certificate of occupancy, is that 2 new bedrooms were added. A bedroom on the first floor and a new bedroom on the second floor, bringing us from the 3 in 1986 to the 5 in 1993. So that's our interpretation of these documents, and we think that that is further supported by 2 other very important documents. And these are the next tabs in Appellant's Exhibit B. So, moving to the third tab, you'll find a 2017 building permit, which was actually done on behalf of my clients, the appellants. They're making renovations to a stairwell. You'll see that at the top of the building permit application, there's black ink, and then there's blue ink in other places. I'll represent to you that the black ink represents what the applicant wrote in, and the blue ink was what was done by the town. So the description of work to be performed relates to the stairwell. The town writes in no expansion, and then they also write in under F, residential, you can direct your attention to that, they put 1 for total single family units, and then 2, they write 5 for total number of bedrooms. So we feel like the town clearly at this point believes that 5 is the number, and we think that's consistent with the interpretation that I just provided. Moving to the next document that we think is very important is a 2008 building permit application, which was also done on behalf of my clients, the appellants. They were doing a kitchen remodel and some other additional work, and this one was actually filled out by Shauna Rohani, who's here tonight and would be happy to answer any of your questions. And I'll represent to you that this one is a little bit more challenging because all of the ink is blue. But the writing at the top, before the break line, where it says, please print applicant to complete, so the applicant to complete box at the top, my client made these marks and described the work to be performed, but then you'll also see 21, there's these all caps, it says no new bedrooms. That is not my client's handwriting, to represent to you. That was not something that she wrote in. That was what the town wrote in. And then the town also made marks below that. And my client, if we go to F residential on this document, because she was under the impression that she had a 6-bedroom home, she had written in herself at number 2, 6 for the total number of bedrooms, and the town sent it back and wrote over it with the number 5. So again, we think this is consistent. I've tried to explain why the thinking was 6 initially, but we think that the town's interpretation in 2018 and 2017 was consistent with the building permit history in 1986 and 1993. And so we think it's clear that this house is a 5-bedroom house. My client was on the market to sell it to a family who presumably wanted to use it that way. That deal unfortunately fell apart as a result of this, and we understand that mistakes in the interpretation of these things can be mistaken and get complicated, so we understand that, but we would ask here tonight that this board affirm what we would call the appropriate interpretation of the 1993 building permit application as subsequently interpreted, by the town in 2017 and 2018. I'll also further represent that the tax assessor's office database records, which of course is not the building permit history, had this as a 5-bedroom single-family home for many years as well. So I have Shauna Rahani, one of the appellants, here tonight. If there's any questions or further explication that the board would like, I'm also happy to answer any questions with respect to the interpretation of these documents. We are principally relying upon these documents as the basis of the appeal. Thank you very much.
Thank you, Mr. Monty. Are there any questions?
Mr. Monty, just for
Yes.
clarification purposes, you entered the listing
Yes.
page. I'm assuming that's for history.
This was the
History.
history, so this was in 2017. This is what the listing looked like.
Right, it's a listing.
Correct.
It's an MLS listing.
Correct.
Okay, I'm just describing it, so I could put anything I want on an MLS listing.
Right, I was just trying to describe that for why my client was under
Okay,
the belief.
that's what I thought.
So
Okay.
just to say, it wasn't like she pulled 6 out of a hat when she bought it.
Yep.
That was the
She
reason
was
for that.
represented that way.
Yep.
Yep.
Can I ask questions about the building permit? Can I ask questions about the building permit?
Sure.
So in section F,
Yes.
Which one?
on all of them, when you're filling out a building permit, whether it's in, read on this one, 86, I think this one's 86. That should be what they have or what they're proposing.
My interpretation, and I'm sure you'll hear from the building official and zoning official next, is that at least with respect to these forms, that reflects the number of bedrooms at the time of the application. Or excuse me, at the number of bedrooms at the time you applied. That's my interpretation of these documents. So in 1986, the person had a 3-bedroom home, and they took those 3 bedrooms and put them on the 2nd floor, and 3 was written in 1993. I agree, 3 is again written in under F residential in 1993. My interpretation is that must mean that beginning of the permit, there were 3 bedrooms.
And then above it, in 18, it says 1 bedroom, 1 bath.
Some of that is even cut off.
Yeah. And then we go to another one that doesn't have a date on it. And that area is not even filled in. So it seems like there's a lot of differences in these permits.
I agree. I think that the permits themselves, and I think it's probably often will find sort of imperfections in their completeness, and otherwise I think that probably happens.
And I'm assuming you don't have any floor plans from
back in.
If I did, I would, yeah, I certainly would have recently looked for those documents, asked the town, you know, what, hey, when these were submitted, did they come with floor plans? If I had those, I would have given them to you. If I had them and they showed we don't have a case, then we wouldn't be here, right? But we certainly provided what we had.
Since we're going down this path, I was going to hold thing after Mr. Zangari's presentation, but on that same 1993 document, in the description 17, I read it this way. Extend north section of house, can't read that part, add second floor to entire section, on first floor, move bedroom and add new family room, so move a bedroom. On the second floor, add a bedroom and a bath and a walk-in closet. I don't see 2 bedrooms being added there. I'm seeing 1 being moved and 1 added.
And Mr. Bernetti,
Yes.
if I may, in my good faith interpretation, that is where the discussion came to raise to change the town's opinion from 3 to 4.
That was my assumption. Thank you.
Yeah, exactly, and it was that language.
Okay, thank you. So my point is, I got to 4.
No, I understand, and again, and
Yep.
not to belabor the point, we think that the 2017 and 2018 permits seem to suggest otherwise, and also it's important that the zoning ordinance that creates an issue in terms of needing the special use permit is a 2021 ordinance. We've got these 2017 and 2018 documents.
Okay, thank you.
So, following up on this line of thought here, the first building permit that we have, I'm also gonna probably struggle a little with what weight to give this evidence. I mean, people make typos all the time on building permits, and they, you know, I get it, but I'm trying to figure out the weight to give. But the first building permit, I see where it says relocate the existing 3 bedrooms to the second floor. So we're assuming that what is on here, they did. So with this building permit, they accomplished what they said they were gonna do. 3 bedrooms got relocated to the second floor. The next application, where it says move bedroom, on the first floor, move bedroom and add new family room on second floor, add large bedroom, and on the second floor, add the large bedroom. So that's where, so there were 3 bedrooms up there, and that's where the 4 come in, when you add the large bedroom to the second floor. But I think we can pretty much assume that move bedroom on first floor, that bedroom was not supposed to be there at that time. I mean, I think we can assume that.
Potentially, but the certificate of occupancy was still granted following this 1993. But yes, I agree that that could be the case.
Right, so I see the 4. And then there's nothing else that addresses the 5 in any of the work to be performed descriptions, but there's just 5 listed in section F at that point.
Yes, by the
Okay.
town.
Okay.
And again, we submit that the 86 and the 93 building permit applications, our reading of that is that it adds to 5. Can I answer any other questions for the board?
Well, there I go.
Not yet?
Would the board like to hear from Shauna Rahani, one of the appellants at all? Is there any questions for her?
I have none at this time
None
for her.
unless she wants to speak.
Thank you, Mr. Pelosi.
Thank you for your time.
You're welcome. Mr. Zangari.
Good evening, members of the zoning board of review. Christopher Zangari, I represent the building official Wayne Pimental in this matter. You want to swear in the witness, please?
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
Sure. Wayne Pimental, Pimental.
Thank you.
Mr. Pimental, Have you had a chance to review what has been marked as Appellant's Exhibit B, which is what I'm showing you now? Have you seen that before?
Yes, I have.
Have you seen all the attachments, and they include the following: the building permit history, which is 3 pages, what's been identified by counsel for the appellant as the 1986 building permit application,
Yes.
and the certificate of occupancy dated March 17, 1988.
Yes.
The second building permit application, which has been identified by council as the 1993 building permit application.
Yes.
The certificate of occupancy dated 11/1/93.
Yes.
There was also an item, building permit application, that was not identified by council or the appellant. There's no date on it. Do you recognize this document?
Yes.
And what is it?
It's a permit to add a 14 by 24 family room addition.
Is it identified in the top right-hand corner as permit number B-489-A?
That would be 00. That's for the year 2000.
Strike that, B-489-00.
Yes.
You recognize the certificate of occupancy dated April 27, 2004.
Yes.
There was another building permit, number B-293-01, that was not identified by council or the appellant. Do you recognize that?
Yes.
Do you recognize the building permit application that was not given a date, but was identified by council as the one with blue writing and some, black writing and some blue writing, signed by John A. Mignelli? Do you recognize that document?
Yes.
And lastly, do you recognize this building permit application? Permit number B73-18.
Yes.
Are all those documents kept in the ordinary course of business by your office?
Yes, they are.
And is it the building, strike that, is it one of the obligations of the building official, one of your duties, to keep such documents?
It is.
Have you had a chance to review those documents?
I did.
I'm going to draw your attention specifically to what appears to be the real salient heart of the matter, which is the 1990, what's been identified as the 1993 building permit application. Permit number 248-93. Did you hear Ms. Corno's interpretation of paragraph 17 just a few minutes ago?
I did.
What was your opinion of what she stated?
What she stated was correct, because all the original bedrooms were moved up from the lower level up to the second floor, so there shouldn't have been any bedrooms.
And how many were on the lower level?
3.
So is it your opinion that all 3 were moved to the second floor?
Yes.
And then based on paragraph 17, was 1 added?
Yes.
That would bring how many bedrooms?
4. Total of 4.
Now we get to building permit B704-17. This is the one signed by John A. Mignelli. Some of it's in black, some of it's in blue. Do you have any idea who wrote the blue part?
I believe it would have been the building official at the time, or the building inspector.
And is there any indication in paragraph 17 if there's any additional bedrooms that are going to be built with this permit?
There was not.
Was there any indication in paragraph 17 of the work to be done in building permit number B-480-11?
There was not.
It wasn't mentioned by counsel, was it, in his presentation?
Not that I remember.
In building permit application B-293-01, paragraph 17, is there any mention of adding an additional bedroom?
There was not.
Was that mentioned by council?
No.
So up until that point in time, there's still how many bedrooms?
4.
Now, when we get to the final, let's write that, not the final, but B704-17, in blue it says no expansion in paragraph 17.
That's correct.
Is there any indication that there's going to be an additional bedroom built?
There was not.
The only indication that there's more than 4 is where? Section.
Section F, number 2.
The fact that that says 5, yet all the building permits before it indicate that there's 4, what does that lead you to believe, if anything?
And it was probably done in error, more than likely, because there's no other permits to substantiate the additional bedroom.
That takes us to the final building permit application that was discussed, B73-18. Is there any indication here that there's going to be, in paragraph 17, an additional bedroom to be added to the already 4?
No, there was not. As a matter of fact, it specified no new bedrooms.
In section F, residential, it says total number of bedrooms. Is that number legible to you?
No, it's not.
Does this have any meaning to you as it pertains to the work that was done previously and how many bedrooms existed at the time?
No, based on the record, based upon all the permits, it was 4, and I saw no reason for it to go up to 5.
If the number in section F, in this application permit or the previous, had said 12, would that make it a 12-bedroom?
It would not.
If it said 1, would it have made it a 1-bedroom?
It would not.
What controls the number of bedrooms?
Basically, the permits that were issued and the indication of how many bedrooms were constructed.
In your opinion as the builder, try that, let me start with something else. How long have you been a building official, Mr. Clement?
34 years.
In what municipalities?
East Greenwich, South Kingstown, and Narragansett.
How long were you in those? How long were you in the first one?
29 years.
Have you had a chance to review building applications?
Yes.
How long have you been with Narragansett?
For 3.5, almost 4 years.
So is it your opinion that based on the review of the records, that this is a 4-bedroom and not a 5-bedroom house?
Yes.
Thank you, Mr. Clement.
If I may be permitted brief cross before the board takes any questions, is that acceptable? Very, very brief.
You know I hate cross, but as long as he's polite and...
I was very, very brief.
As long as you're polite, Mr. Murphy.
I will be polite.
We'll allow it.
Thank you for your testimony, Mr. Pimentel. I just want to confirm one aspect of your testimony. I believe you said that in your interpretation of the 1986 permit was that the applicant at that time moved 3 bedrooms from downstairs to upstairs. Is that correct?
That's correct.
And that was approved?
That's correct.
And then your interpretation of the 1993 permit was that a bedroom was added to the 2nd floor, correct?
A master bedroom?
Is that correct?
I believe so.
And I believe you also testified that that permit said move bedroom on 1st floor, correct?
Correct.
So that suggests the total number of bedrooms was 5, doesn't it?
It wouldn't, because when the 3 were moved from the 1st floor, there were no longer any bedrooms on the 1st floor to be moved.
Correct, but if the applicant was writing move bedroom on 1st floor, it suggests that in fact there was likely a bedroom down there, correct?
I'm not going to speak as to what may have been down there and what the building official interpreted when he read that description, but based upon all the permits and what's written in those permits, 3 went upstairs, there were no longer any downstairs, so it would have been impossible to move a bedroom from the lower level unless it was done illegally.
Okay, so the 1993 permit, there's 3 upstairs before it, there's a 4th on the 2nd floor, correct?
Yes.
And then there may have been what you've termed an illegal bedroom on the 1st floor, correct?
That's the only assumption I can make.
Okay. Notwithstanding, the certificate of occupancy is granted for the work referenced in the 1993 permit, correct?
It's referenced, but it's not specific as to the number of bedrooms.
Correct,
It's
but
very general.
but a CO does issue for that permit.
It does issue for it.
And what happens prior to a CO issuing?
There's final inspections.
So somebody goes and looks through the house?
They would, but at the time, there would be no furniture in the house, so wouldn't be possible to determine if there was a bedroom in that wall.
How do you know there'd be no furniture in the house?
Because when we do final inspections, we don't allow furniture or people to move in until the final inspections are completed.
Well, if someone's doing an addition, they already live there, don't they, in most cases?
They would, yes.
And the 1993 is about an addition, correct?
That's correct.
So there probably was furniture, correct?
More than likely.
Okay. And the 1993 CO does in fact issue following an inspection of the house, correct?
I don't know if it was for the entire house or just for...
You don't know what in particular, and how could you?
Yeah.
But a CO does issue for the 1993 permit, which does suggest there were 5 bedrooms, but one of them may not have been above board in your opinion at that time, correct?
That would be correct.
Okay. But the 1993 CO issues, correct?
Yes.
I don't have any further questions. Thank you.
You're welcome.
Do you have any questions? Are there any questions? Mr. Zangari, do you have?
No, thank you.
Mr. Monty, is there any chance, I'm looking at the 93 building permit application that you've just been discussing, which seems to be the determining factor here on the number of bedrooms. Have you attempted to contact Mr. Wilkins, the contractor?
I attempted to contact Mr. Bill Hansen, the owner, and I was unsuccessful in that endeavor. The 1993 contractor I have not attempted to contact.
Well, Chris Wilkins, he lives 2 streets over on Narragansett Avenue. As far as I know, he's still there. I mean, and he was a former town councilman, as well as a contractor. I imagine he could clear quite a bit of this up. Just a suggestion.
May I have a moment with my client?
Sure, absolutely.
So it's our opinion that the records we just went through and even the testimony of Mr. Pimentel confirm that there were 5 bedrooms at the house and that a 1993 building permit application was granted a CO, and that 1993 building permit references 5 bedrooms total, even though one of them was moved, right? I mean, I believe the official testified that suggests there were 5 there. So we don't think that the testimony is necessary. We think you have enough before you here tonight to make the decision.
May I ask a question? So, turning to the 93 permit, we were focused on section 17, but if you look at section 18, where it says use of each floor, you have basement, unfinished storage, first family room, I'm assuming it's kitchen and everything. But second says 2 bedroom, 2 bath. It might even be 1. I'm giving a grace there. I'm giving a. But the second says 2 bedroom, 2 bath. So maybe. I don't know.
No, and I agree that
I don't know what that means
interpreting
because
these documents, I think these documents are challenging to parse through for these very types of reasons. You know, and on some of them, and these are the best records we have, some of it's cut off, mistakes can be made on them. but the interpretation I described is, I think, the correct one, and I actually think that the building and zoning officer's interpretation was the same as mine in terms of the number of bedrooms, and then just a different conclusion that I don't agree with, for the reasons previously stated.
Oh, I think part of the problem with these applications, Mr. Pimentel will tell you, everyone that comes in and fills them out
Right.
differently.
Right.
You know, is it, when
Right.
when asked total number of bedrooms, is it existing or proposed? And correct, Wayne, that you- oftentimes,
Absolutely. I mean, and with Ellen's comments, I would just say that on the first floor, it just says family room, doesn't even
Yeah.
mention the other
It
bedroom.
is cut off a
supposedly
little, there's
moved.
some stuff cut off.
But it, you know, it just references the one new bedroom.
But it is in the homeowner's writing, because it's the same writing as
Yes.
the description, so they put 1 or 2 bedrooms on the second floor there, they admitted it, I don't know, it's just confusing.
I don't know. I think the 93 permit really explains it. In 18, they're explaining the changes. So they added, they were changing the bedroom and bathroom, and then the family room on the second. But then they were also, with the extension, the first floor got a family room. But in the permit before it, 86, it said that they're relocating bedrooms. They didn't say, so they're moving all the bedrooms to the second level. So that one says 3, and this one says 3. From what the solicitor was saying, if this is where the town is gonna opine to say that there was 4, but then you go to a 2001, they wouldn't even talk about bedrooms.
well, that's what I'm saying about these, but very often they're very vague. You know, and unfortunately, that's what we have to go by. But, I mean, there's a discrepancy of 1 bedroom.
And I just, if I could just add, you know, reading that, that section, it says, extend north section of house out 12 and a half, or assuming feet, add second floor to the entire section on first floor. Then there's a dash in between, it says move bedroom and add new family room on second floor, add large bedroom. It could be assumed that one of the second floor bedrooms was being moved, and that was becoming a larger bedroom, because under section F, it still refers to it as the 3-bedroom house, which is what's proposed, not what's existing. I mean, it's not an easy determination.
Right, it is,
But
it's not, it's black and white, but it's not. Mr. Zangari, you look like you have something to say.
I just have a couple of comments, just a couple of remarks, that's it. I think the applicant's argument rests on 2 things. To get to 5 from 4. That when the 3 bedrooms are moved up, a certificate of occupancy issues, and then somehow there's a bedroom counted below, whether it's illegal, I don't know. But if it is, the building official made a mistake at that time in calling it 5. And also, they also hinge on the fact that there's a 5 written on the existing number of bedrooms in the second to last building permit application. Whether that's right or wrong. That hinges, that's the 2 things you're saying, look, someone wrote down 5, and they probably counted a unit when they issued the CO as 5. So I think what they're really resting on is there have been 2 mistakes made, 2 errors by the building official at the time, 30 years ago roughly. And because, not 30, one of them was 30 years ago, but then one of them was 15. Those two issues, you're somehow stopped from saying that this is now prevented, from saying that this is now a 4, because somebody made those mistakes. If those mistakes were even made, that's what they're relying on. So I'll leave it at that.
Is there any dispute in the evidence that the tax assessor's plat map or card has 5 bedrooms on it? They testified to that, but
It did.
It did?
But again,
I mean,
those,
I know, I'm just asking if we were just.
those are strictly referred to as for informational purposes only.
Okay,
It's not,
Okay.
it's not the
Okay.
legal set of accounts.
Yeah,
So-
and ironically, there were 6, it was wrong either way,
got it, okay,
because there were 6 bedrooms there at one
got
time.
it, okay.
Just out of curiosity, when did town sewers going down there?
Say that
When
again?
did town sewers going down there? Was it a septic system at one point?
They went in the 90s.
Yeah, it went
Right, Mike?
from, in the
We'll go with the town historian. It may have been before that, actually.
Nah, I don't think so.
Yeah.
I think it was the 90s.
The 86 permit shows it as a septic system.
Mhm.
The 93 permit shows it as sewers.
My client can answer the septic question if you're interested in getting that answer. So,
I can help with some of this.
You just,
I don't
you
wanna
just need
extend
to
it,
be
but I
sworn.
will.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Please state and spell your whole name.
Shauna Rihani, Rihani. First name S-H-A-W-N-A, I'm sorry. So as to the septic situation, it was on private, and that's probably the reason, initially on the 86 permit. And so that's probably why they limited it to 3 when they relocated the 3 upstairs. Then in 93, it was attached to the sewers at that point. Just to address your question about the, you had noted that 2 of the permits, which we didn't reference because there were no bedrooms constructed in those permits from what I understand, that was an additional family room and a laundry room. So I completely agree that this is all very subjective. It's difficult to know what people were thinking 30 years ago, and I understand their perspective as well completely. Just a couple of points of clarification. Part of the reason I think that it was at some point considered a 6, and again, this is just looking at the documents and trying to understand what they were thinking, is I actually think that section F at that time was used to state the number of bedrooms that would be in the newly constructed section. And so when you look back at the 4 permits that were referenced, you have when that laundry room is built on that permit, you had pointed out specifically, oh, there's no bedrooms written there, but that's because that section contains no bedrooms. And then when, the same is true in the living room permit. When there was a living room permit, there were no bedrooms constructed in that section. So what's interesting about the permit that we're all focused on in 93 is they say 3 there. And in that addition that they built at that time, there is the 2nd floor bedroom, the master, that we can all agree was added. But then on the 1st floor, there is a family room, but there are actually 2 other rooms down there. And so when they listed it as a 6, it's because there are 6 rooms that would be classified as bedrooms. Not legally, of course, but you would look at them and say, oh, that's a bedroom, oh, that's a bedroom. Now, I had seen the discrepancy between the MLS listing and the tax assessor's site, and it was only 5. So in my mind, I thought, oh, okay, well, on that permit where they wrote 3, there are these 3 rooms constructed in that addition on the 93 permit. One of them was approved as a bedroom on the 1st floor, whether it was potentially, I don't want to use the word illegal, but that's what it would have been. So if they had some room they were considering a bedroom on the 1st floor, separate from those 3 that they moved to the 2nd floor, then they would have moved it to the newly constructed section, and then it was inspected and approved. And so that's why we think so strongly that it's 5, because we have the 3 that were relocated upstairs, and then we have the 2 that were approved in the subsequent CO. So there was maybe one other question about like the specifics? No?
I have, if this is an inappropriate question, just ignore it and you don't have to answer it. But Could you just explain to me why it is important that the house be designated, well, 5 bedrooms?
Yes.
Why don't you just do what everyone else in the town does and just use it as a bedroom?
So, well, because, okay,
I mean-
so a couple of reasons. So first of all, I'm a real estate appraiser, and so I know how important it is to have accurate records. And what's a little bit, makes me a little nervous about this conversation is I understand that the public record is not the Bible. It is not the final say. But when I do appraisals, that is what we use, you know, to be in accordance with the rules, to confirm any details about the property. I use that record, so I would like it to be corrected. And, you know, I use it as a rental. We all know how contentious the situation is. You can't rent the bedroom if it's not legal. Now, the family that I was selling to, they were planning to move in. I've actually moved out of state and I would like to move on from this, but you know, the number of bedrooms, it affects the value. And because when we reflected on the historical record, and it did indicate, although somewhat subjectively, that it was 5 bedrooms, I just thought that we should pursue it.
And Shauna, just to clarify, did the town's position as to the number of bedrooms cause the purchase and sale
Yes.
agreement to sell to the family to fall through?
Yes.
And so now does the property remain a rental?
Yes, and I would like it to go to 5. So when I told them I'm working on this because obviously we thought it was initially ruled to be a 3. Remember, it's not like we're coming to you, this is a continuation of this process. They said, no, this is a 3, we're so sorry. And so I said to the buyers, okay, I will work on this for you. I'm sure I have the permits, we can get this fixed. And then they said, okay, well, if it's only a 3-bedroom, then we're going to give you $200,000 less. And so I said, okay, you know, I have this, let me do my best. And so that's why it's important. And for them, they're not actually planning to rent it, but they don't want to buy a property that is, it's 3,800 square feet. This house is gigantic. I mean, what do you do with 3 bedrooms? And at that time, when the deal fell through, because they said it was 3, you know, it just doesn't make sense. It's a 3-bedroom property that's 3,800 square feet. And we have the rental history. And the last thing I would say is all of the public record did Northeast reevaluation, the assessor's office, they all indicated it was at least a 5-bedroom. So.
And just to clarify, the deal for the purchase agreement fell through after the town said it's 4, correct?
Correct.
So 4 was not acceptable to the family that was purchasing.
Let me ask one question. Was it listed as a 6-bedroom when you were going to sell?
It was listed as a 6-bedroom, but I did explain to them that on file was, because at that time it said 5 bedrooms on the tax assessor's site.
Yeah, I just want the record to be clear that it was listed as a 6-bedroom.
How?
So therefore, if there were less bedrooms than as it was listed, it may not have been the determination of the town which caused
but that's
the
actually,
transaction. It was listed as a 6-bedroom on the MLS. So that's as far as I'll go with that. And all this is extraneous to the determination of the building official, which you're here to either uphold or overturn. And Ellen, to answer your question, the reason why it's theoretically important, so, is that if there's a determination that there's 5 bedrooms, then the next step would be for Mr. Monti to pursue his declaratory, you don't have the power to say it's a pre-existing non-conforming use. He could then move forward in Superior Court to have the court declare it a pre-existing non-conforming use if the 5 bedrooms came before 2021. Another option would be they could come back tomorrow and ask for a special use permit for a 5-bedroom. Seems a simpler route, but I guess the step 1 is for you tonight is just to determine whether Mr. Pimentel's determination is correct or whether they're or incorrect. And then I know Ms. Morris got angry at this, but then we'll head up to the Superior Court and we'll litigate it further because that's what we do here.
Can I just say one thing?
Oh.
I just want to say, just one note, it actually, the buyers were happy with 5.
Mhm.
Was
I
there a
explained-
contingency in the purchase
Yes.
and sale agreement?
Yes, I made the
I
contingency.
cannot
One at a
take
time.
both of you.
So this will just be our last question. Was there a contingency in the purchase and sale agreement that the deal would go through if it were a 5-bedroom?
Yes,
And is that the contingency that caused the deal to fall apart?
yes.
So that's why 5 is important in one respect, but also we feel like very well supported in the documents we presented this evening, in the testimony of Mr. Pimentel and the testimony of my client. And with that, we'll conclude. Thank you.
Thank you.
Steve, I don't know if this has any bearing, but I think it may. I knew the Hansons, and they had, and I can't tell you how many bedrooms were there, but they had a number of adopted children. I actually coached 2 of the boys at baseball,
I
and
mean, I don't believe it's relevant. You're really,
no, I'm just saying, I mean, it's very possibly
you can certainly disclose it.
the number of kids that lived there, so. In regards to, Rouhani, what would the board like to do?
Mr. Chairman, just 1 second before we start. I'm sorry. Just a question for Steve. Can you remind me, because I missed the last appeal earlier today, what's the standard of review?
More than a scintilla, less than a preponderance, is that what we, more than a scintilla, less than a preponderance? I'm looking at Mr. Zangari.
That's my understanding. My understanding of what that means is significant evidence. Significance being more than a scintilla. A scintilla is a sliver, less than a preponderance. The preponderance would be more than 50%.
And Mike, if you want to weigh in on that.
Yeah, we strongly disagree with that. There are different standards of review for appeals of different types of decisions. So a decision from the planning board to the zoning board, that may be the appropriate standard. In this type of situation, which is more akin to the denial of a building permit, the board is just stepping into the shoes of the official and making the determination anew. I can
with the standard.
I can follow up with citations to that effect if it's helpful, but that's our position as to what the standard is, that you're basically making a de novo determination.
With, and again, you know, is there substantial evidence in the record? So all those cases, I'm not even going to get into it. So, yeah, Mr. Monte's saying this board doesn't have jurisdiction, and yet is going to cite cases that says this board has jurisdiction. So, but with that said, let's make the decision one way or the other. We have applicants here.
Chair would entertain a motion to close this hearing and then we'll come up with a decision.
So moved.
Second. Any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0. In regards to Rouhani, what is the board's pleasure?
Mr. Chairman, my motion is going to be to uphold the building inspector's decision. The evidence provided and the discussion we've had mostly around application 248-93. In my mind, the description is clear. We didn't add 2 bedrooms there. We added just the 1. So we got from 3 to 4. The certificate of occupancy doesn't describe how many bedrooms were there. It just basically is referring to the building permit application itself. The other applications with the cross out in the blue and black with 5 total bedrooms on one. And according to the appellant's testimony, the original 6 and then changed to 5. To me, I believe those just to be errors. As we describe, these things aren't. Everyone, different people, different inspectors for these out and different inspectors for these. So my motion is based on this evidence to uphold the building official's decision.
Second.
The motion has been made and properly seconded to uphold the building official. Is there any discussion on this motion? I'm kind of torn on this one. It's just, like I said, when you go through these, you can see both sides. We talk about move the bedroom on the first floor. They don't say they're moving to the second floor, they just say they're moving. So I can see where Mr. Monty and the applicant believes that there is a 5th bedroom, so I don't know. I'm torn on this one, but all those in favor?
Aye.
Is that voting? I stepped in a couple minutes afterwards. I don't know if I'm voting or not.
Who's voting down?
I think it should be,
Chris came, he
Like
walked
a
in
minute.
as soon as the hearing began, but he didn't sit.
No, so in that case,
We'll have
if
Al.
he missed it, yeah, so we have 1 in favor, Chris, 2, did you vote in favor?
Christine,
3.
no. Okay. Those in favor of the motion to uphold the building official?
Aye.
Aye. I'm gonna oppose it, but, so that motion carries 4-1 to uphold the building official.
Thank you for your time.
Thank you.
Thank you.
Hopefully it doesn't hold it against me. Want to take a little break? All right, we're gonna take 5 minutes, and then we'll get right back to it. continue. Next item on the agenda, Gilbertson, by M, lot 167-98, located at 33 Shore Road, in Breakwater Village. Gail, are you handling this?
Yes, I am.
Good
How are
evening.
you? Good evening. Is this the official?
It should work.
Okay.
Could you raise your right hand, please?
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
Okay, Gail Hallett, Hallock, Sear, C-Y-R.
Thank you.
Okay, so this is another one of those little buildings in Breakwater Village where it's an antiquated building that's not really good for hurricane or for the code, and as you can see, they're right on the water. It was time for my owners to rebuild and put in a nice little cottage that's complying with the design guidelines of Breakwater Village. And that's the existing one-story dwelling. So right here you'll see there's a 50-foot CRMC setback, which greatly limited what we ended up doing in the new house because we wanted to push all of the roofed area back behind that CRMC setback. In addition, of course, we have the two 200 square foot parking spaces which are going to go in there, and that kind of also put a big dent in the footprint that we were able to build. And as you know, in Breakwater Village we have the FAR that is restricted according to the lot size, and in unit 98 is approximately 1432 square feet. So there was the allowed FAR would be 859 square feet, and we ended up only being able to fit 844 square feet. In addition, because it's less than 2,000 square foot lot, there's only 40% of the second floor, 40% of the gross floor area is allowed for a second floor. So there's a lot of restrictions in this tiny lot, and so we pushed a very small lot into as big a house as we could, and it's tiny. But we did it. So we're looking for the relief on section 4.4 Coastal Resources Overlay District, 154 foot variance and special use permit, section 4.8.1.5 dimensional regulations, 1.6 right side yard setback variance, and I'll explain. That's the one that is kind of non-standard for Breakwater Village, and I'll explain that in a minute. And then section 4.8.1.6F, Breakwater Village Special District, special use permit for a 25% or greater footprint expansion. So can we have the new site plans? So as you can see, we we have that 50-foot setback, and we have the house, and then the two parking spaces here and here. So it kind of knocked a corner out of the footprint that we were allowed. And if I could have the first floor, oh wait, actually I do want to see where it says proposed porch. That's the one that we're asking for a variance on, because they wanted to have a door in the side, which makes the most sense with the floor plan, and have a hood over it, so you've got a little bit of protection from the elements when you walk in. So here's that portico right there. So this is the side door. It comes into the kitchen, the living room, and actually this is the dining room. These are teeny spaces. It's 20 feet by 21 and a half this way, and then there's like a 5-foot extension here that's by 16 feet. So we've gotten the living room, kitchen, bedroom, and bath all into that, along with the second floor staircase. And the most logical place to come in, of course, is to the kitchen. This is the area toward the view. And that red line there is the coastal setback, and so we're just beyond it. now there is the sun deck that we proposed, which is also below what is allowed. That can overhang because it's not roofed. So on the second floor, that's where it is, and it's 85 square feet. And I can't remember what there it is, but the bedroom number 2 is also on the second floor. That's the master, and has a tiny bathroom and closet and a little bit of laundry up there, and that's 40% of the gross floor area. So, is there a 3D of this? Yeah. Okay, so here's the front elevation, and that shows the deck. And so again, all of it, the height is below what we're required to have, the size of the FAR, everything is below except for, and here's the deck. As you can see, it's got sort of brackets holding up that deck, which is over that coastal setback, but because it's not roofed, it's not something that they're going to worry about. But the rest of it has to be behind the coastal setback. And see right here, that's that roof extension. So we've got side roofs that kind of divide the height of the building, so that it masks the fact that I've actually stepped back 1 foot on each side here in order to create that 40% that maximum that I'm allowed. So that roof covers that, but then this is the roof over that side entrance, and I deliberately kept it really free and clear, as minimal a footprint as I could, and so that it would not overhang and impede anybody's view as they're looking down the street, and it wouldn't impede anybody walking by. So while we meet that 5-foot setback here, that one actually, goes in 1 point, whatever it is, 1.6. Okay. So yes, there it is. So you see, it's a little bit of an extension off that roof that again masks the setback on the second floor. It just kind of pokes that roof out. Actually, it's 9 inches, I think, that we were poking out above, beyond where that roof is. So it's for a few reasons. Obviously, they would like to have a portico that kind of protects them from the rain as they walk in. It's also a design element. This facade would be kind of square and boring, but this adds a little bit of, that New England style, that Breakwater Village style. It, breaks up that facade, adds interest to the facade, and again, I think I've said already that I designed it as small as possible. I didn't even put overhangs past the brackets because I was trying to keep it really tiny. So that's our big ask. Usually we behave totally, but we have one little teeny roof that we'd love to have dimensional variance on. And there's the rear, that goes down into the basement, under the stairs that are here. You can see, again, it doesn't poke out very far. And this all is like only 5 feet away from the side yard setback, from the side yard property lines. So they're all within the setback there.
Gail, what's the dimension of the lot again?
35, thank you, 35 by 40.58. Or actually on the other side it's 41.25 evidently, so it's not exact, it's square.
It's pretty well thought out.
Thank you.
Just say that. You did a lot.
It is.
You complied with a lot.
We tried.
About as much as you possibly could, yeah.
We really squished it in. Thank you.
So just for the record, Kelly, the structure itself
Yeah,
meets the requirements, it's just
Yes.
that small overhang.
yeah, that one with the X, but all of the rest
Everything
is
else
right
is,
within the setback and, you know, it's proper size. It's actually 15 square feet below the maximum bar that we're allowed. The height is lower than the allowed height.
Yeah, why do you need a special use permit? Because it looks to me like you're
I-
limiting, or you're not expanding the footprint. It looks like it's getting smaller to me.
I know, it does sort of me, but I'm sure these guys know, they look at every number, and I'm sure it is a little bit more than 25
I just don't
feet.
understand that. It looks
Yeah.
like the footprint of the building is being
No,
compressed
it really does. Yeah, because the old,
from what was there before.
yeah, you can see the old building was sort of here. So I guess, I don't know, maybe it's equal, or, I don't know, I have no idea. It probably tells on the original.
Yeah, there was a 25% increase, which triggers a special use permit
Yeah,
requirement.
yeah, I'm sure they
they had a
they
valid,
count,
they had
they
a
really
valid-
count, yeah.
Gail, how much is the overhang? I heard 9 inches and I heard 1.6 is what you
Oh,
need for, so.
Well, so the 1 foot of roof overhang is allowed, it's just that this,
The additional 9 inches, is that what you're
yeah,
saying?
Yeah, so you don't see the roof, I'm sorry, do you wanna go, Wayne?
Nope, go ahead.
Okay, you don't see the roof overhang on the site plan?
No, you
And
do.
so 1 foot of ornamental, an ornamental roof overhang is allowed,
Mhm.
ornamental feature, I think is what it's called.
Right.
When you go beyond that, you know, I liken it to the front yard setback rule, go back to the beginning. So,
You
and
take
what they're
the-
showing here, we measured is about 1.5,
You go down.
1.9,
1.6 you would have on
do we? Okay,
That was
okay.
them, just saying.
So that, it's
So-
an extra
so
point
you-
six.
This is
You
math,
get to point
Mr.
six,
Van.
that's
Yeah.
That's not good enough, so that's-
When you factor that in,
Yeah.
you eliminate the foot and add it to
Yeah.
the overall thing. I mean,
If
once
they-
you go
if they're-
beyond the foot,
Once you go beyond the foot, you
Okay.
go back to the beginning. Mhm.
okay,
Baseline, so, got it.
all right. Any further questions? No? Thank you, Gail.
Thank you.
Is there anyone that would like to speak in favor of this?
Well, we would.
We
We don't think we have to go up to the podium, but there's certain, we support everything she says.
Unless you get sworn, you're not supposed to. They'll throw me in jail. All right, is anyone opposed that would like to speak? Okay, Chair would entertain a motion that we close this public hearing.
So moved.
Second.
Motion has been made and properly seconded. Any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0. In regards to Gilbertson, what is the board's pleasure?
Mr. Chairman, members of the board, with respect to project summary Gilbertson, tax assessors plat M-167, lot 98, dated May 8th, 2024. The applicant has submitted a request to demolish the existing dwelling and construct a 2-story dwelling with a 2nd-story deck on the south elevation at the property. The project requires a variance and special use permit from the Coastal Resources Overlay District, Section 4.4, a variance from the dimensional regulations, Section 4.8.1.5, and a special use permit from the Breakwater Village Special District, Section 4.8.1.6, subsection C. We heard tonight from, first of all, I'd like to accept the findings of fact in the project summary A through K. We heard tonight from the architect Gail Halleck-Sear, who described a severely constrained lot in Breakwater Village, in which she's done, I think, an outstanding job in designing a house that will be, as the staff noted, more conforming than the existing dwelling, as it will be over 50 feet from the coastal feature, which is further from the coastal feature. than the existing one. We heard from no individuals in support of the request and no individuals in opposition to the request. The planning board recommended the application to the zoning board for approval. Planning board found the application to be complete and found the application to be in conformance with the land use component of the comprehensive plan of Narragansett, and recommended it to the zoning board for approval, subject to conditions 1 through 5 of the project summary, with the vote on complete and conformance of 5-0 passing, and a recommendation of approval with the motion passing 5-0. I would also like to note that there was testimony on the record tonight that the height is below the allowed height in Breakwater Village, which appears to be appropriate for this particular property. And within the allowed FAR. And that completes my findings of fact.
A second. A motion has been made and properly seconded to enter the findings of fact into the record. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed? That motion carries 5-0.
Mr. Chairman, members of the board, with respect to project summary Gilbertson, dated May 8th, 2024, I'd like to make a motion to grant the relief requested, specifically from section 4.4 Coastal Resources Overlay District, the 154-foot variance and special use permit, from section 4.8.1.5 dimensional regulations, a 1.6-foot right side yard setback variance, and section 4.8.1.6 subsection, I thought it was C, but is it C or F, Jill?
F.
So it's referenced as C in the summary, but it's F. Summary on page 1.
Yep. F.
F. So it's from section 4.8.1.6F, Breakwater Village Special District, special use permit for a 25% or greater footprint expansion. I believe that the applicant has met the standards, specifically that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not to the general characteristics of the surrounding area, and is not due to a physical or economic disability of the applicant, that the hardship is not the result of any prior action of the applicant, and does not result primarily from the desire of the applicant to realize greater financial gain, that the granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of the zoning ordinance or the comprehensive plan of the town of Narragansett upon which the zoning ordinance is based, and importantly, that the relief to be granted is the least relief necessary. I think, once again, we've seen Ms. Sear here design a very lovely home in a very constrained lot, and do it in a way that it meets all of the standards of the zoning ordinance.
Second. A motion has been made and properly seconded.
Conditions, I'm sure.
No. So just an error, Mr. Alman, it's actually subsection D, not F. My apologies.
So I will amend that to granting the relief requested from section 4.8.1.6D, Breakwater Village Special District special use permit for a 25% or greater footprint expansion, and also make my motion for approval subject to conditions 1 through 5 in the project summary.
I will amend my second.
A motion has been made and properly seconded to grant the relief requested with conditions. Is there any discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed, that motion carries 5-0.
Thank
Good
you.
luck.
Thank you so much. Thank you very much.
Nice and easy, right?
Thank you.
All right, next item. Murphy, 207 LLC / Murray, Flat E, Lot 102, 207 Ocean Road. Good evening, Laura, how are you?
Good evening, I'm fine, thank you.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
My name is Laura Krikorian, K-R-E-K-O-R-I-A-N.
Thank you.
I am an architect. I'm sure the board knows I'm licensed in Massachusetts, Connecticut, and Rhode Island. I have been in business 30 years, and my office is right in Wakefield on Main Street. I'm here tonight to present the application for 207 Ocean Road, Murphy 207 LLC, and Tammy Murray, who is the property owner of this particular property. They have owned this property for about a year, and the family is very excited because it's really an investment in family and family time together. They do own the property across the street, and the Murray kids do love to come and visit their mom, and they like to stay. So when this property came up for sale, they were able to purchase it as a home that will be a place where their kids can stay when they come to visit their mom. So it's really an investment in family and family time together. This site is in the Pier area. It's Plat E, Lot 102. It's an 8,716 square foot lot in an R10 zone, so it is a substandard lot of record. The site plan, if you could go to that please, shows that there is an existing house and an existing detached garage structure on the property. The site plan also does reference the renovation of the house, but I just want to make sure it's clear with the board. I did submit an updated site plan that states that we are only addressing the rebuilding of the garage tonight. We did submit this entire application for the renovation of the house and the garage as one project back in November. When we realized that the house met all of the zoning requirements and the garage rebuild was going to require a zoning variance, we did separate them into two permits. The house actually is under construction right now. The garage is sitting waiting for hopefully a zoning variance tonight. So the application tonight is strictly for the rebuilding of the garage. There are a couple of important items that I feel are unique about this particular property. One of them is that the house and the garage have been in these exact same locations for over 100 years. We did find them both on some of the Sanborn maps from 1921. So that was kind of a neat feature about this particular property, and we aren't razing the house and taking it away and demolishing it. We are working with some of the really neat existing proportions and details about the structure of the house. And in looking at the garage, part of the reason why we decided that we needed to demolish it was because of the condition of it. The structure of the garage is a wood-framed structure. It is actually got a wood floor with a large wood ramp that goes up to the wood floor. The floor of the structure is about 30 inches above grade, and the ramp is really cumbersome. It's a little steep. I can't even imagine trying to drive a car up this ramp to get into the garage structure. the framing of the floor is in bad shape, the sills are rotting, the footings underneath the structure are crumbling, they're rubble and stone. So when we were looking at this garage structure, it seemed more prudent. It's also not clear that the footings go down below the frost line, and it certainly isn't anchored to meet any of today's wind loading requirements. So with all of those issues with the garage, it seemed more prudent to demolish it and rebuild it as a new structure. The location of the garage on this lot was really important. I mean, it was placed there 100 years ago, and it is neatly tucked back behind the house in a very discreet location. It forms an edge to the rear yard of the house, and it allows this backyard area here to almost feel like a courtyard. It's a really beautiful garden space. So when we were looking at rebuilding the garage, the kind of neat thing was that we have an opportunity to do a little bit of redesign. We did, first of all, remove the ramp from the structure, so that removed about 363 square feet of coverage from the lot. We also changed the proportions of a little bit. We made it a little bit narrower and a little bit longer, but it's still smaller. I think the existing structure, well, the existing structure was larger. It shows on the original site plan the size. It was 365 square feet before, and now it's 315 square feet in terms of the footprint of the actual structure itself. With the rebuilding of the garage, we were also able to change the location of it just a little bit, but we were hoping to be able to keep it in the same corner on the lot so that we don't, first of all, disturb more of the lot, so that we don't change the view corridors that any of the people behind this lot are looking through. But we did shift the structure a little bit further towards the street, so the actual back edge of the garage was at 6.9 feet before. The back edge of the garage now will be at 10.9 feet, but there was a request for a second stair, so we did add a stair on the back that will still align with the existing rear yard setback. So the rear yard setback is still being requested to stay at 6.9 feet to the actual stair, but the building itself will feel and look further away from the property line because the building is shifting. We also were able to shift the garage a little bit south, so away from the side property line. It was, I didn't label it, it was closer before, and now it was 4.2 feet to the property line previously. Now it's 7.2 feet to the property line. So the request is for the side setback to be 7.2 feet. If we were to try to meet the setbacks, because we did study the lot and see is there some possible way that we could meet the setbacks here, if we were to shift it further south and try to meet the side yard setback, the garage doesn't align with the driveway anymore. It starts to overlap the house, and it would be really difficult to drive in the door. If we were to try to meet the front yard setback, the rear yard setback, and shift it closer to the road, it begins to overlap the house, and it encroaches on the porch area, it encroaches on the windows, and it closes off the access to the rear yard from the driveway. So keeping it in the location that it has been in for 100 years was a really important part of this whole project. And it's, I feel, really where it belongs, in that northwest corner of the lot where it isn't blocking any southern light for the house. It's tucked back neatly and discreetly in the rear yard, and it does align with the existing driveway. I feel that the hardship that we're facing here is unique to this property. The structure was built well before there were zoning laws in existence. It was placed thoughtfully on the site, as I said, tucked back in the rear of the property and aligning with the driveway. In terms of the the use of the structure, the first floor will be just a garage. There's an overhead door and a slab on grade, and they'll be able to drive the car right in and use the back area for some storage. We did place the outdoor shower on the back side of the garage, and there was a request from the Murray kids to have on the second floor a small private kind of flexible space where if a few of them came to stay and one of them needed to work remotely, for instance, for a couple hours in the morning, they would have this private space that they could go up, be quiet, do their work, and then join the rest of the family. Some of the other kids were looking for a place where they could put out a puzzle table and not have to put the puzzle away because it's in the middle of the dining room table. Or a place where they could play games or watch TV. So it was really a flexible kind of family room space that they were looking for with that second floor. The other request that we're asking for tonight is a very small height variance. The structure existing today is 16'6" to the peak. We're asking to be able to go to 17'11". Part of that number was because I was designing last year with last year's ordinance where 18 feet was the requirement, so I did manage to keep it under last year's ordinance. But we felt that some of the design elements about the proportions of the structure were important as well. The house itself, we were taking clues from. It's a 1.5-story cottage, so the cottage gave us some clues as far as how to design the garage as well. We chose the 1.5-story wall. It has the exact same roof pitch as the house does, and it has 2 little gable dormers that face into the rear yard. On the house, there are 2 little gable dormers that face opposite into the driveway. So the house and the little garage then begin to have a dialogue and look like they belong to each other. Some of the other features are little roof overhangs that give it some character, but we also worked hard to minimize the height request as well. The overhead door is only a 7-foot high door. The floor to ceiling in the garage is only 7'6". The floor to ceiling upstairs in the second floor down the center is 7'8". So we're not asking for 10-foot ceilings and massively tall spaces. The other thing we did manage to do, and I know it's a matter of inches, but with the garage being a little bit narrower, we were able to use smaller floor joists to make that span. So that was a couple inches that we reduced the height in that area as well. So we did work really hard to minimize the request for the height, and it is only a little bit taller than what the structure is today. I do have some sketches, if anyone would like to see, that I could introduce, that show, may I?
You may.
Sorry, I didn't
Sorry,
bring
we'll share
it.
that.
So keeping the garage in the location that it's in today was really important for the client as well as, I feel, for this property. The main reason is that it's been there for a long time and it was thoughtfully placed on the lot, but it also will allow us to disturb much less of the lot and maintain more open space that all of the neighbors in the back are accustomed to looking through. So we feel that the location of it is really important to be able to rebuild it in that same spot. So I do have Tammy Murray here with me tonight. She's the property owner, and if you guys have any questions, that's all I have for you.
Laura, just one question. The backs, the rear yard setback was 6'9" and now it's 10.
So it was 6.9 and it's still 6.9 to the stairway that we're adding back on the back side of the structure. But the actual building itself, the massing and the wall of the building is 10.9 feet away from the property line.
Thank you.
Yep. So visually, it's going to look like it's further away because the stair and the platform are an open deck structure.
Understood. Thank you.
You're welcome.
So, you're saying that the use of the upstairs in the proposed garage is going to be somewhat of a family room thing. Will there be sleeping there? You did notice this was a guest cottage. You kind of said it was a guest cottage, so.
Did I call it that?
That's what you called it, so.
There is no, and I've talked to the Murrays, there is no intention of adding any kind of a kitchen or making it into any kind of a dwelling unit.
No bunk room?
There isn't any sleeping that's gonna be happening up there. It's a family room.
Is that against the rules, if it was? No. Oh.
No, I mean, for this, it wouldn't, because there's an egress door directly to the outside. I believe they're on sewers, so
They are on sewers, yep.
there would be no restriction, except for parking.
Right.
Laura, what
And it
about-
wouldn't be considered a bedroom. How many bedrooms are in the existing house? It doesn't, because it's
In
an
the house?
accessory.
There are 4.
Okay. So that wouldn't be a 5th bedroom that there?
I mean, it's not designated as that, it's
Okay.
designated as, what, a game room?
It's a family room, so I can explain, if I may. On the first floor of the house, just so you understand what this space is maybe a little bit better, there is a bedroom, a bathroom, a powder room, a laundry room, and then there's a large open area that's kitchen, dining, living. So there's no other family room space, there's not a den, there's not a place where, for instance, the parents could watch a movie and the kids could go play games or, that kind of space. So it really is a family room space that they're planning for.
Okay. And I think you said that the downstairs, in this cottage or garage, the downstairs ceiling height is 7'6".
Yes.
And that's because you can't go any lower because of the doors, the way the doors come up.
You need the overhead door to have
okay.
room for it, and it's a low headroom track as well. You can see that note right there. So yeah, the 7'6" was the minimum.
Was the minimum.
Yep.
Okay. And then upstairs 7'8".
It is that's to the ceiling.
To the peak.
Yep.
Well, is it dormers or?
So it's a sloped roof, and then there are collar ties. So it is actually a sloped ceiling up to a small flat spot down the center, and that center area is what 7'8".
Okay.
And Wayne, that would, if, for this particular use, you would require 7'6" minimum on that, or?
It would be, 7 feet would be the minimum.
7 feet.
Yeah.
Okay.
It is only a small strip down the middle that's actually 7'8". The rest of the ceiling's sloped. Yep.
Okay.
It's just enough to fit the 3068 door down the center there.
So as far as the height variance goes, Laura, that's predicated more on the overall design, the architectural effect from the exterior?
It definitely has a lot to do with the design and trying to kind of mimic and take clues from the house. I mean, even if we were to do a lower roof pitch, I feel like it's going to look odd there and not be in keeping with the character and the scale of the house.
There's 2 dormers on one side and one on the other?
The other,
Is it
could you go back to the plan?
Shed
Yep,
dormer?
there's a shed dormer
A
across
shed
the
dormer,
back.
okay.
Yep, on the side, sorry.
So that actually increases the height on the inside where it's sloped? I mean.
Yes, but even this here, did I include a cross-section in the set of drawings?
You may have, but I don't know, I didn't put it in.
Because it would show what the height is there. Wait, I have the drawings. I can tell you what the height of that. I think it's 6.5 feet to that. To this point is 6.5. So even that is coming down low.
Any other questions?
Yeah, Laura, you talked about using materials to help reduce the height. Floor joists or?
Oh,
ceiling
so the
overhead?
floor, when we were able to make the building a little bit narrower this way,
Mhm.
the floor joists here span from outside wall to outside wall. As the building gets wider, the joists would have to get deeper in order to span further. So reducing the width actually allowed us to squeeze down the floor joists a bit to gain, to pull the height down a little bit.
Mhm.
So I was looking for every inch I could find.
Thank you.
Mhm.
Anyone else? Thank you. Is there anyone that would like to speak in favor of this proposal? No? Is anyone? Is anyone opposed that would like to speak? All right, that's always an encouraging sign. Chair would entertain a motion that we close this public hearing.
So moved.
Second. Motion's been made and properly seconded. Is there any discussion? Hearing none, all those in favor? Aye. Opposed, that motion carries 5-0. What is the board's pleasure?
Mr. Chairman, we have a project summary. Murphy 207 LLC, tax assessors plat E, lot 102, dated May 8th, 2024. The applicant is requesting to demolish the existing garage and construct a new garage slightly smaller, including a rear deck, porch, rear addition. No, that's not true. This is strictly for the garage. Existing conditions show that the building is in tough condition, and as opposed to rebuilding would need to be demolished. It was represented by Lord Krikorian, testified that the lot is substandard lot of record. They are only rebuilding the garage. The location of the building is essentially the same as it's been since 1921, slight adjustments. As I said, the condition of the garage has declined so much that it should be demolished. It's supposed to be rebuilt. The building is slightly smaller than the original. The original was 365 square feet, and now we're at 316 square feet. The rear setback was 6'9". It's still 6'9" to the staircase, but 10'9" to the rear wall of the garage, so they actually moved it closer to the street. And it was also moved south. Was 4.2, and now it's 7. So it's 4.2. The reason for the height has to do with the design of the property, the design of the building itself, to make the house and the garage complementary. Quite a bit looks like it has been done to reduce the relief for the height. So there's been some effort there. The applicant is looking for relief from section 6.4 dimensional regulations for a 14-foot rear yard setback variance, a 3.2 right side yard setback variance, and a 1-foot 11-inch accessory structure height variance. Staff has provided 6 conditions that we'll talk about in a minute. The planning board has reviewed it, has talks about adding an additional condition that there shall be no kitchen installed on the second floor of the proposed garage.
Can I ask a question about that one?
Did you close the public hearing?
Yes.
I think they're striking one.
Yeah, I'll get there. I'm not there yet. So the answer is no.
Okay.
Sorry.
Can you address that when we continue?
The motion from the planning board to be complete in conformance was 5-0, and they recommended approval 5-0. Those are my findings of fact.
I'll second that motion.
A motion has been made, properly seconded to enter the findings of fact into the record. Is there any discussion? Hearing none, all those in favor? Aye. Opposed, that motion carries 5-0.
Mr. Chairman, with regard to the same project summary, my motion is to grant the relief requested from section 6.4 dimensional regulations for a 14-foot rear yard setback variance, a 3.2 right side yard setback variance, and a 1-foot 11 accessory structure height variance with conditions 2 through 6. Did you get to read my site plan? In one? You've received it? Yes. Yep, again, I hit you. Thank you.
We did,
Okay.
Mr. Brunetti, yes.
Okay, so the conditions 1 through 6?
No, 2 through 6.
2 through 6, I did that. And, I do want to add this. So I do want to add the condition that the planning board recommended that there shall be no kitchen installed on the second floor of the proposed garage, so it would be 2 through 7.
I'll second that motion.
A motion has been made and properly seconded to grant the relief requested with conditions. Is there any discussion? Hearing none, all those in favor?
Mr. Chairman, one thing that I wanted to know.
I'm sorry, Chris.
So this particular project summary is being presented under the new ordinance,
Yes.
which does not require a finding, or a finding that the standard that is the least relief necessary needs to be met. And I know that we've struggled with that standard in the past with respect to height variances. So I just wanted to point that out to the board before we took a vote.
Thank you. All right, that being said, all those in favor?
Aye.
Opposed? That motion carries 5-0. Good luck.
Thank you.
You're welcome. All right, next item.
Thank you.
Murray, Plan N-N. Lot 1-1-A, 101 Old Boston Neck Road. Mr. Callahan, good evening.
Mr. Chair, good to see you tonight, members of the board. My name is Callahan of Callahan, 3 Brown Street, Brookford. Thanks for your time. It's been a long night. Gotten through it very well. I'm here tonight on behalf of Terry and Nicole Murray. Murray's own property located at 101 Old Boston Neck Road. As you all probably know, that is a somewhat secluded road, sort of shaped in a U off Boston Neck, connecting Sprague to the Nancook Farm area. Murray's property measures 102,000 square feet. As you can see on the screen, it's rather large. But notably, the residence on site is very understated, classically so. The residents also, I have some photographs took today, avoided the rain in the morning, so I'd like to present those just for reference. A copy for you. Thanks. Gives you a better idea of the actual scale of the property and the residence. But as you'll see, the residence has a unique farm-side seascape aesthetic, which I think should be commended. It's really a one-story building, has a barn feel to it in a way, a big red door to the left, as you'll see in the photographs. The shingled structure that's on site only measures 1,300 square feet, so it's rather small. The proposal here is to create a accessory unit with garage space to the east, southeast of the current structure. So we'll be down in this area where the red dot is. The new unit would be 1,042 square feet, and will be very consistent with the architecture on site. Again, one story with a small loft space. We're asking for a height variance, and that's the only relief we're asking for the accessory unit to be 21 feet and 1 5/8 inches high. And I think that's the exact same height as the current structure on site. Again, we don't need any of the relief, no lot coverage, no setbacks, nothing. And again, the lot itself is very large. With a lot this size, there could be a home on site that measures 9% of the lot, which is almost 9,000 square feet. So it could be a mansion, but it's not. That's not what the Murray's is sought here. The total lot coverage would be 2,342 square feet, which again is minimal. In theory, the Murrays could have built a connector between the two homes and made something much bigger. That just wasn't what they were looking for in this instance. They're seeking a small space with no kitchen to accommodate their children who have friends, partners. They want to see their family often, but just not sit in their laps as it is now. Additionally, just for reference and context, without the zoning change that took place in December, this may have qualified for a modification, but again, that's water under the bridge. And we feel this proposal has merit because it's understated, well-conceived, and contributes to the architectural quality of the area. If you know the area, every other house nearby is 35 or more feet high. We have 2 letters of support, which are unsolicited, I must say, to Terry's credit. And I think those are in the file. And also the Murray family, there's a lot of Murrays around, but I know Terry wouldn't say this, but they've been tremendous benefactors of the town. Contributed to the field, the high school, the library, just a tremendous family overall, and they've been very nice to Narragansett. So I know, again, he wouldn't say that, so I feel I have to. But overall, I think this is a proposal that really doesn't push the boundaries in any real way. And there's a septic system on site that would fit 6 bedrooms. With this situation, it only gets to really 3 bedrooms with a small loft space for storage in the unit. There's really no basement area, there's no shed, there's no closet space to speak of. This will just allow them a little additional space to store things at certain times. So with that, I'd ask Paul Weber, Paul Weber Architects, to come to the podium.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and spell your last.
Paul Weber, W-E-B-E-R.
Thank you.
Paul, can you give the board some of your background from work and education?
I attended Rhode Island School of Design and graduated with a bachelor's in architecture, and since then have practiced architecture in a number of firms in Boston and Connecticut, and about 15 years ago opened my own firm called Paul Weber Architecture in Newport, Rhode Island. We work on primarily residential. We do some work for private clubs, and we also do some active work for universities.
And you testified as an expert in the past in other towns, including Newport?
Yes.
And that's where your office is located?
Yes, our office is in Newport.
And approximately how many times?
Probably half a dozen times.
With that, I'd like to ask
Mr. Callahan, for the purposes of this public hearing, Mr. Weber will be recognized as an expert in the field of architecture.
And Mr. Weber, is it fair to say you've worked on this project for some period of time?
Yes.
And can you bring the board through your thought process and how this came to be?
Sure. We were asked by the Murray family to propose a second building for the site, and to make it very similar to the original building. That is a 1-story building and similar in dimensions, and so that it presented itself as a little, like a sister building to the existing.
And in the proposed building, it's really just a garage, a bedroom, and some storage space, no kitchen, correct?
That's correct. There's no kitchen. There's just bedroom, garage space, and a loft space for storage. Again, the storage is because there's no basement, and there's a very small basement in the existing house.
And the height of the proposed structure is 21 feet, 1 5/8 inches?
Yes, to match the existing house, correct.
And if Murray were to build like a connector between 2 buildings, is it fair to say that the building could probably be significantly larger?
Yes,
One of them could be.
It could be significantly larger, right.
But that wasn't something the Murrays wanted to do for a variety of reasons, is that fair to say?
Right, right.
And in your opinion, does it make having the structures consistent make them more attractive?
Yes, definitely. Since two buildings were really designed to be almost identical. We felt that, that the proposed building should also be the same height.
And what is the purpose of the loft space in the,
Just purely storage. No sleeping, no nothing, just storage.
is there any other area where you can really store something or is there ample space for additional storage in either building?
Well, I think there's a small basement in the original house that just houses some mechanical space.
It's fair to say the Murrays could have built a much larger structure on the site, really any time.
Yes,
based on lot.
yes, they could have built a considerably larger building.
And is there a type of architectural design that this is called, or?
Well, we would call it sort of agrarian or farm-like, a rural-looking structure, and we felt that it was appropriate for the sort of the large field that it sits in.
Is it fair to say that the hardship is due to the limited size of the current structure on site?
Yes,
And that is not due to the general characteristics of the area?
correct.
And if this variance is granted, it will not alter the general character of the area in any way, will it?
No, it will not.
And it will not impair the purpose of the zoning ordinance or the comprehensive plan?
No, it will not.
And compared to other buildings or homes in this area, is it fair to say these two combined are somewhat small in comparison?
Yes, these two buildings are really the small guys in the neighborhood.
Anything else you'd like to add?
No, I think that the materials will be the same, shingles and with wooden shingles and similar windows. It'll be very much sort of the same character.
Thank you very much. Any questions on the board?
Yes, Alan.
Can you tell me the height in the storage area? What is the height of
At the
of
very
floor?
center, it's 9 feet. And at the little wing wall, or the little knee walls, it's 2'7".
So, and the ceiling,
Yeah.
ceiling goes down like that, so it's
Yes.
2'7" to 9 feet at the center?
Yes.
Okay. How far out does it go where it's, say, 7, how much space is there? It's about 7.5 feet, like how do?
Probably
So
like
like
4
where?
feet. You know, there's,
Okay.
maybe pointed, you know, there's probably headroom right where the door is. You know, 6 feet headroom.
And the storage space does not cover the entirety of the home, correct?
Correct.
Only about a little less than half?
A little less than half, yes, correct.
And the other side is open to the, that's a
It's a cathedral
it
ceiling.
could be cathedral ceiling and,
Right.
okay. Can anyone, as Chris had mentioned with the last thing, I think we struggle with the least relief necessary when we're under this. So can you comment on that? Is there any way you could reduce the height of that?
I just
Right,
want
by the,
to clarify, I know that's in the staff report. That provision doesn't apply in this instance. This is submitted.
I think it was under the old.
No, we submitted this in January.
So let's see, because that might, that's a big difference.
So, Mr. Chairman, the building permit application is B23, which means it would have come in 2023.
Came in
But I
20.
submitted the application.
You did. So it was not clear that you wanted to come under the old rules, the new rules, Mr. Callahan, because the building permit said 23, so we processed it under the old regulations.
How
They
can
have the option to come in under
Yes,
the
he
new.
does.
Can
Yes,
he
he
say
does.
that right now? Can he ask for that right now? Or does it have to go back?
Well, either way, I mean, if it,
Steve,
well, if that's the way it's being viewed, we will.
Yeah, no, so just what we did is any applications that were put in around that time, we allowed the applicant to choose. I don't think it would, in my opinion, it doesn't have to go back through the process.
Okay.
You know, it seems to me that's the reason why it's being reviewed under the old standard. However, it would seem beneficial. It's up to you and your client to decide which standard you wish. However, it seems that the new standard would be better. In my opinion, we don't have to run it through at this point.
No, I understand. I see what you mean. I never didn't take it that way, but I think either way, we have to prove a variety of things to you. And if we do go based on least relief necessary, I think we can make a case that is least relief necessary at this point to move forward, because based on Mr. Weber's testimony, there really could only be 3 feet, 1 5/8 inches. I think that's what it is. So can you speak to that, Mr. Weber?
I'm sorry, what is the question?
Regarding the least relief necessary,
Right.
if this building were...
So the question kind of is can you reduce the height of the building and the ceiling by 3 feet and still get storage up there? And I think with 9 feet, I think the answer is yes, you can. But
Well, we actually did a little sketch to do that study, and we came up that we'd only have, at the very ridge, we'd have 6 feet, and only 6.5 feet would be all that we have at the ridge to barely move the stand up. So we feel the loft space as a storage space is compromised significantly.
I think personally that,
I know you hate those guys.
I know we're not an architectural review board, but and everyone knows my feelings on the accessory height restriction in this town.
Because it's
I mean, if
it's
there's-
awesome. It's beautiful.
Yeah,
I mean,
if there's
works
something
really
that
well.
screams, you know, for a variance, it's this, you want, it's a perfect setting for it.
Yeah, I think the justification of keeping it the same height as the
Right.
existing
Makes sense.
structure makes sense, whereas I'm not sure that we've seen that before, at least in my experience, where
I mean, I really hope
the
it's
variance
something
was
like this.
necessitated by the fact that they wanted to keep the height at the same height as the house. Most of the houses are much taller.
Right.
Where we see an accessory structure height variance.
And so, Mr. Weber, based on the analysis that you did, in order to use that as storage space in an effective way, if it's reduced further, someone will have to crawl around in there to do
Someone will
stuff,
be-
and that doesn't make any sense to me.
You're absolutely right.
Okay.
Anyone else? Okay. Does anyone need to hear any further testimony? All right, is there anyone that would like to speak in favor?
I think it looks nice.
If that was only the
Is there
only
anyone that is
concern.
opposed or would like to speak? Okay. Mr. Callahan, I believe we've heard enough.
Yes, I agree.
Chair would entertain a motion that we close this public hearing.
So moved. Second.
Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0. What is the board's pleasure?
Mr. Chairman, with regard to project summary, Murray Tax Assessors Plat N-N Lot 1-1-A, 100 Old Boston Neck Road. I make a motion, I will move these findings of fact that I'm going to go through be submitted into the record. The applicant is requesting relief from section 6.4, the dimensional regulations with respect to the height of an accessory structure. We are working under the older rules where we have to make certain findings, and the relief requested is for a 3-foot height variance. The proposed improvements include construction of a 52 by 20 accessory structure, 1 bedroom on the first floor, a 1-car garage also on that first floor, and a second floor storage loft. The applicant, along with their architects have took great pain to make this be a structure that fits in with the existing house. The house is the lot size of the house is 102,000 square feet. Is that what somebody said? So quite the large lot. We don't have any other issues to worry about with respect to lot coverage or FAR or anything like that. And the design of the house fits in very well with the surrounding areas. We also heard testimony from Paul Weber of Weber Architects that that helps us decide that the standards have been met in granting the relief requested. So the hardship from which the applicant seeks relief is due to the unique characteristics of the land. It's not the result of any prior action. Will not alter the general character of the surrounding area. And the relief to be granted is the least relief necessary, and that's the one that I think I struggle with. But I do see that there's evidence that it is the least relief necessary, given the fact that we want that you want to have the same height of the accessory structure as the house, which is not something we've met with before. I will also mention that the planning board did find the application to be in conformance, but they did recommend denial in this case. I think that concludes my findings of fact.
Second. A motion has been made and properly seconded to enter the findings of fact into the record. Is there any discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed? That motion carries 5-0.
Mr. Chairman, again, with respect to project summary Murray, tax assessors plat N-N, lot 1-1-A. I would make a motion that we approve the application for the dimensional variance for a 3-foot accessory structure height variance. Based on the testimony presented today, Done. With conditions, yes, with, except for, so, recommend for approval with conditions, except condition 1, which is the height, the condition that would have reduced the height of the garage, of the accessory structure in the garage.
2 through 6.
2 through 6, with conditions 2 through 6.
I'll second.
A motion has been made and properly seconded to grant the relief requested with conditions. Is there any discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed? That motion carries 5-0.
Thank you very
Good
much.
luck.
Thank you.
Thank you.
Thank you.
That's it, right? Nothing left?
Nothing left, we're all done.
We're all
Oh,
done,
no,
right?
all done.
Okay. Finally, last
make it
but not
quick.
least, we have Morris, tax assessor plat N-S, lot 524. Good evening, Ms. Saunders.
Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name and spell your last.
Yes, Amy Sonder, S-O-N-D-E-R, East Works and Associates.
Thank you.
I am here for the Morris project for a proposed new deck. Unfortunately, the family can't be here tonight. They had a death in the family very close to this family, so they cannot be here.
So, we really want to get this deck for them. They own the house there at Lot NS 524. They've owned it for quite a while, and they bought the house as is. There is a small deck to the north corner, kitty corner to the structure now. I don't know if you have any plans that I submitted at the planning board, but I have a couple of copies of what the deck looks like now from the street. A couple of these. There's two images underneath there as well. It's a very small deck, and with the doors and the entrances and windows, you can basically get 2 chairs there. It's not very conducive to gathering and getting together as a family. So they'd like to expand the deck, as shown here. We did submit an earlier plan that was requesting 2 feet closer to the street line and 50 square feet more than I am proposing this evening. But as a recommendation by the planning board, we accommodated those 2 recommendations. We took 2 feet off of the deck and increased the setback to 4 feet, and we reduced the deck by 50 square feet so that it's now 405 square feet, including the steps. This type of situation is pretty well known in Bonnet Shores. I did work to the lot just to the north of this, and I have pictures of that, and the deck there is also, it's hard to read, but I put it in yellow so people could see it. The deck to the north here is also, here's one more. 4 feet to the property line as well. We have a large shoulder area there. If you can see, Withington is a very narrow road, so the deck would actually be, as proposed, 19 feet to the edge of pavement. So there is still a good amount of room between the deck and the roadway there. We did propose, because they would prefer not to have any railings, they just want it low to the ground and open and inviting, that we would put some plantings there to help alleviate people running right off the deck onto the road. So this is what we're proposing, and I think there's a coverage. We have a little bit of a coverage relief as well to increase the deck. But we're only at this point increasing it approximately 170 square feet. So keep that short and sweet. If you have any questions, I do have a couple of pictures of actually some other similar situations in the neighborhood. Right here, and this one is exactly the same. It's actually it's less. It's 15 feet to the edge of the road and 2 feet from the property line. This is just a little further north on Withington. There's one more here for you. I've got one here. Okay. Basically, they just want a little bit more room to gather outside. This is their summer home. They don't live here full-time, so their enjoyment is outside during the summer months, and using the deck areas is very conducive to that time period. So we would request that you would grant these variances for us.
So it's, the relief requested has been lessened.
Yeah, we reduced it. I reduced the deck 2 feet to the north, and they did have fully wraparound stairs around the whole deck in the beginning, and then I don't know, do you have pictures of the deck as well? underneath the site plan here, I have a couple of these.
Oh, okay.
Yeah, sorry.
That's all right.
Yep, I got more of these too. I think I have two more. If you take underneath the site plan, you can see what they're proposing. Kind of primitive plan of what the deck would look like, with some plantings, with two steps going down. If you went further to the north, they have a grassy driveway area, and it would impose into the driveway area. So there's really no place else to expand the deck than what I'm showing. And we wanted it on the west side because they like to watch the sunset over West Quaker Pond. And not sit on Bayberry Street.
Amy, what are the dimensions of the deck existing now?
Well, we're only adding 2 feet to the north, or excuse me, 2 feet to the west, so it's 9 feet with that step. It's actually, I think it's only 8 feet with that step. I have a scale, hang on 1 second. So, it's 5 feet on the north, and then on that far left side, it's 7 feet. So if you, right here, this is 7, and right here is 5. And then on that northerly side, it is 7 as well. So they're adding 3 feet on the northerly side, and approximately, it looks like a little over 2 feet on the, or 3 feet it would be. So 4 feet on the northerly side, or westerly side.
And actually, your relief requesting is very northwest corner. And it-
Yeah, it's the northwest corner. It's
And it
the way the
reduces-
house sits on the lot and the angle of Withington. You know, it's just that one corner area. They could, with a modification, skim a weird angle off the deck,
Mhm.
but they didn't like, they really liked the square cottage, you know, in keeping with the area. It just looks unusual to have a big angle going down the side of the deck.
How much would they have to cut that corner if they were to cut the corner to make it meet?
To do it depends. I mean, if they just cut it with the, you'd have, it would be a weird angle.
No, hold on.
Is that what you're asking?
No, I don't think so. Like if they just cut the corner, like made it,
Well, see where the line comes in? This is the modification.
yep.
So it would be at the full length if they did that.
Oh,
You know what I'm saying?
because
the line,
there is
You'd
still,
be back,
Yeah.
you would be back in here and
yeah, okay,
and then
okay,
it would be.
Yeah.
okay.
I mean, if you just did a 45, you're
Yeah,
still looking
right.
at relief with a 45. You're still close to that
Unless you
Withington
came
Road.
really far back.
Just
it wouldn't
because
make
of the
any sense.
angle of Withington.
Right,
The only way, I mean, you,
If it was a square lot, it would be, yeah.
yeah.
so,
And if you take off that little, you're back to the narrow deck, and if you look at that picture, you have 2 chairs sitting on the building, and nobody can really sit at a table and chat or gather.
anyone else? No? All right, I'm gonna ask for proponents and opponents.
Let's stand up at once.
I have to ask.
I think it's a lovely deck.
All right, Chair would entertain a motion that we close this public hearing.
So moved.
Any discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed, that motion carries 5-0. What is the board's pleasure?
Chairman, members of the board, with respect to Morris, location 65 Bayberry Road, tax assessors plat N-S, lot 524, would make the following findings of fact. First, I would incorporate into the findings of fact the May 8, 2024 project summary, the report and survey that is contained within that of Amy Sonder dated April 11, 2024. And I think there was another plan given to us today. Is that a revised plan from what's in the folder?
Oh, the one that I just handed you?
No, this was,
The one that was on your desk is the revised plan that was submitted a while ago.
April 24th
Yeah.
is the last.
So this is the one that reduced it from what the planning board.
This is, yeah,
Alright,
the April 24th is the modification per plan.
Got it. And the modification of the plan that was provided to us as an exhibit. The applicant is seeking to demolish the existing right side yard deck and construct a new right side yard deck, which is going to be, according to the staff report, 24 feet by 22 feet. Testifying on behalf of the applicant today was Amy Sonder. She testified regarding the information contained in the project summary that the proposed deck will be roughly 405 square feet. That she, after attending the planning board, reduced the prior design to one that comported with the planning board's recommendations. Also at the hearing today, Ms. Sonder provided additional exhibits which show a better graphic, I would say, than what's contained within the summary, that shows that the actual, I guess it would be the westerly, northwesterly edge of the deck is really like 19 feet from the, what would be Withington Road.
The road surface.
The road surface,
Yep.
and that it's all grass in between there, just so it's clear on the record. They're seeking a 2 feet, 0.41 right side yard setback and a 3.75% lot coverage relief. Ms. Sonder, which I think was also helpful, submitted other examples, photographs of other examples from the neighborhood that had decks that are in similar locations in proximity to the road. And lastly, it was pointed out to us, which is also depicted in the exhibits that were recently provided, that the lot itself is not a perfect rectangle, and in fact it kind of narrows down as it moves from east to west, and that's on that western boundary is where the deck is going to be located. That concludes my findings of fact.
Second?
a motion has been made and properly seconded to enter the findings of fact into the record. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0.
Chairman, members of the board, I would move to grant the relief requested under section 6.4 of the ordinance dimensional regulations to grant a I'm getting trouble with it, I don't know why I can't say this, 2 feet, 0.41.
2.41 feet.
There we go, 2.41 feet right side yard setback. I think it's because it's in black on my thing. And a 3.75% lot coverage variance. I think there was sufficient testimony in the board, in the record from Ms. Sandra that the hardship from which the applicant seeks relief is clearly due to the unique characteristics of this subject piece of property and not to the general characteristics of the surrounding area, nor is the hardship due to physical or economic disability of the applicant. The hardship is not the result of any prior action of the applicant, that this particular deck and property has been like this for a significant period of time. And I think the significance of the photographs that were provided to us showing other properties in the neighborhood is to show that the granting of the requested variance will not alter the general character of the surrounding area or impair the intent of the zoning ordinance or the comprehensive plan. And I guess there are some conditions in this, conditions one through 5.
I think you want to eliminate 1, don't you?
Yeah, I don't know, Jill, I'm not clear on that, because it looked like this document, when we came in this morning, was the modification from the planning board recommendation. So is that the modification that's being referred to in number 1?
No.
No.
Okay, so we don't need number 1?
No, you don't.
All right, well, that's easy.
Thank you.
With conditions 2 through 5.
I'll second that.
A motion has been made and properly seconded to grant the relief requested with conditions. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed? That motion carries 5-0. Thank you, Amy, and good luck.
Thank you very much.
Jill, do you have anything for us?
You better not.
So for several months, you've had the draft template in front of you. I have received 0 comments on that, which is good, right? So if you're all set with it, next month I will take the watermark off and you
Jill,
should
I
be
might
good to
have a
go.
couple comments.
Great, if you have
Yeah.
now, or
No,
just email to me and
I'll call you.
all right, sounds good.
I'm sorry, I just looked at it this week.
All right, anything else?
No.
Okay. Chair would entertain a motion to adjourn.
Oh,
So moved.
Second.
All those in favor? Aye. That motion carries 7-0.